May I permit to mention one thing? This is a committee MD. With the award not, but they are not.
Give a notice to the others.
Lordship,
Your Lordship,
Give a notice in writing.
Lordship, may I permit to mention on criminal revisional matter for extension of interim order? Lordship, I serve notice upon the private opposite party as well as the state. Lordship.
And when is it expired?
Lordship, 30 of November.
30th November expired.
Lordship.
You filed any application?
Lordship.
Yes.
Your Lordship, may I be permitted to mention one criminal revision?
Grateful, Lordship.
Your Lordship, may I be permitted to mention one criminal revision for extension of interim order? Your Lordship, the interim order would expire on 31st January of 2025.
Yes, please go.
Lordship, may I permit to mention a matter, Lordship?
Give the number. Where is the sleep?
Sleep, my learned friend will supply the mentioning.
Who is your learned friend is not here.
Lordship, may I permit to mention a matter, Lordship? Civil division, Lordship. There was a direction to file affidavit in opposition. Till date, the respondent did not file, Lordship.
Next circuit.
Lordship, kindly, Lordship.
No.
Implementing matters, my lord, inclusion in the list for delay already come. And there is a cross appeal also.
Delay condone paper books prepared. Huh? Now you are who is on the other side?
Other side is a cross appeal also.
You are for the insurance company. Cross appeal insurance company is fine. Who is for the insurance company?
Still without one.
You have given notice. No.
Your Lordship, Your Lordship, sorry to interrupt.
Lordship, I want to mention one FMAT execution case already been filed before the learned lower court, and learned court lower court has directed to file the attachment petition. I am on behalf of the insurance company.
So if you don't pay, then attachment order will pass.
So I want to stay.
Who is on the other side?
Other side, notice has already been served through post.
Oh. No application again, admission. Appeal has been admitted.
Yes, appeal has already been admitted. Execution case already filed by the claimant in the meantime.
Have you filed any application? For
Yes.
Stay?
Stay. Can one.
Can one. The appeal admitted. Notice has been served.
Yes.
Notice of appeal has been served.
Yes.
Notice দিয়েছে? Other side? দিতে পারো. Give a notice to the claimant. Give a notice to the learned advocate for the claimant and then mention here.
Other side.
The interim order will expire in this month, 31st January.
CRR, civil, what?
Yeah.
Interim order. Chalo. Document.
Item number one, I'm for the petition. The complaint is, unless it was registered matter against the petitioners along with Padeshwari Roy, Kailash Roy and Kiran Chandra Roy. The allegation leveled against the allegation making the complaint is that the opposite party number 2 entered into an agreement with the accused number 1, Padeshwari Roy. Wherein Padeshwari Roy agreed to sell 6 bighas of land to the opposite party number 2. As advance, an amount of rupees 10 lakh has been paid.
Which Roy?
On the page, complaint is at page 14.
Yeah.
Page number 14.
Yes. Padeshwari Roy.
Yes, ma'am.
Agreement was entered between the complainant and Padeshwari Roy.
But that agreement is at page 19, ma'am.
Hmm. Agreement for sale of what? Flat?
Of a land, ma'am.
Land.
Six bighas of.
Okay.
Thereafter, mother, as per the complaint, she has paid 10 lakhs to the owner of the land. And
Padeshwari.
Padeshwari, as advance, mother. And my lord, subsequently thereafter, she came to know that the said Padeshwari Roy entered into an agreement with the opposite party number, with the petitioners here, my lord, that is accused number 4 and 5, my lord.
Yes, 4 and 5.
Yes, and she, when she came to know, she tried to alert us that see, this Padeshwari Roy is not entering, is not performing the contract. She has not yet submitted me the documents, furnished the documents. You please don't enter into an agreement as per the complaint, madam. And thereafter, when I insisted her that I am confident, I can purchase it. She said that okay, I have paid this amount. Okay, so you then you give me the profit of the sale procedure. This according to complaint, this was the case, madam. But in petitioner's version is that, madam, she had the opposite number 2 acted as a middleman. She was paid a sum of rupees 10 lakh from, my lord, a company, my lord, which is named as Image Wincom, my lord. If it also kindly comes to page 26, my lord, 27, my lord,
27.
27. She entered into an agreement with Image Wincom Private Limited, my lord, wherein she accepted 10 lakh rupees against that property, my lord, as advance, my lord. The total consideration was 16 lakh. My lord, will find at page 29, ma'am. Her claim is that she has not been refunded that 10 lakh rupees and also the profit, ma'am. But she has already received 10 lakh through my another company, ma'am. Subsequently, my company purchased the land, ma'am, which is at page 36, ma'am.
How many times this is being made? July 14. This is first
Yes,
agreement.
yes. Actually, she acted as a middleman. We had no knowledge that she entered into an agreement with Padeshwari, ma'am. We paid her 10 lakh. Where we kindly see the acknowledgement.
Who are you? You are the subsequent purchaser.
Yes, subsequent purchaser.
How come you are the subsequent purchaser? Nomita Padeshwari, June.
Yes. The amount that she has received, my lord, at a time of making the consideration amount, my lord, you will also will find the money received, page number 47, my lord, that I have indicated that the landowner has received a rupees 10 lakh to the opposite party number 2. It has been indicated here because I, through another company, has already paid the opposite party number 2, who entered into agreement with Padeshwari Roy. So there is no dispute with regard to her non-payment of 10 lakhs. And with regard to the profit portion, there is no such agreement to that effect. What she has alleged in the complaint now. So this is a purely a civil case, and at best non-performance of a contract now, which she has not gone into, madam. Only to
What
harass
is the
petitioner.
amount paid in the agreement of Nomita
Yes,
with the company?
yes.
You are not the company.
But I am a different company. The company who paid to
No, no.
Nomita is.
Let me understand.
Yes,
Nomita has subsequently entered into an agreement.
yes, with Image Wincom Private Limited.
Image Wincom.
Yes.
The Image Wincom is not your company.
It's a
Sister concern. Sorry, sister concern.
sister concern.
Oh. So you have paid the amount.
Yes, to this agreement she has received, and her acknowledgement is at page 34, madam. Kindly see. 34. Despite receiving the sum, she has lodged this false complaint against the petitioners and challenging
The
their.
sale between Nomita and Padeshwari, that is completed.
No,
Hmm.
that has not been completed.
So again, an agreement for sale has been entered.
Yes, yes.
At the instance of that
Please,
opposite party.
please.
Sir, Rajat, this is my.
No. Mr. Pal is there. Mr. Pal is there. At the instance of the opposite party number 2, the entire thing has been done, the subsequent agreement also.
By challenging the issuance of process matter, I went before the district judge.
Hmm.
That has been rejected against this favored distribution.
What is the ground?
On the page, it's after page 51. Madam. You see, certificate copy. Madam.
Certified copy. Which is the page number in which there is discussion?
Yes, madam. Well, here. But page number 7, page number 3, internal page number 3, madam. The second paragraph, madam. The observation made herein is not different. Madam. In the course of hearing, learned lawyer for the divisioners did not deny, rather admitted to have taken 10 lakh. But the petitioner revisionist has never taken 10 lakh from the Nomita. Rather, they have paid to a different company. Observations have been made wrongly, madam. The facts have been recorded wrongly, madam.
Oh,
The complaint is totally silent on this regard, madam, that she has received 10 lakh subsequently. It's totally silent.
where from I will get that the 10 lakhs were paid to Nomita? the
Yes, ma'am.
company?
Madam, page 37. Madam, the 34.
That agreement.
Yes. 34.
Agreement page number?
Madam, the agreement starts from page number 20.
No, payment.
Oh, payment. Madam, payment 34. Page 34 is the payment.
By check, the amount was paid.
Who is the signatory for Inmage Vincom in this?
One of the director, his name is Shyam Sundar Goel.
Sam Sundar Goel.
Yes.
Sam Sundar Goel is a petitioner here.
No.
What is the status of Manoj Kumar and Rinku Agarwal?
Manoj Kumar and are the directors of Bal Gopal Cosmo Sales Private Limited.
How this?
They subsequently purchased the land, madam. And Malad, the adjustments were made. If it tally comes to 47, Malad, the amount paid through that check, this is the adjustment, Malad, 10 lakh. We just paid to Nomita. This is the adjustment amount, Malad, because
Page 47.
47.
How many times Nomita will
Nomita
take money?
paid
Nomita
for
has
check.
taken money from Image Income.
Yes.
She has also taken money from you.
No. She has paid directly to the owner of the land.
Okay.
And she has taken money from us. So that has been adjusted.
Okay. This criminal revision is fine. Challenging the order dated 7th April 2016 Okay. Serve notice.
Ma'am, I will pay, stay of the proceedings. Because I have obtained bail, ma'am.
You have obtained bail.
Yes, ma'am.
No. Order dated 23rd February 2023. In criminal revision number 28 within brackets 7 of 2016, passed by learned additional sessions judge, second court at Siliguri. Dismissing the criminal revision and affirming the order of the learned Judicial Magistrate Third Court Siliguri dated 7th April 2016, passed in CR case number 219 of 2016. Mr. Is
Mr. Rajat.
no, Rajat Das.
Lordship, Lordship.
Rajat Das. Mr. Novankur Pal, led by Mr. Rajat Das, or the petitioner, submits that the accused number 1 Srimati Padeshwari Rai became the owner of the land measuring more or less 6 bighas appertaining to plot number 225, 221/1266 and 226/127 within Mouja Binaguri by virtue of a registered deed of sale. For sale of the land, the said Srimati Padeshwari Rai entered into an agreement with opposite party number 2, Srimati Nomita Agarwal. Opposite party, she is the complainant.
Ma'am.
Nomita,
No, no. Yes, ma'am. No, Mr.
complainant. Opposite party number 2, complainant Srimati Nomita Agarwal. In the month of June 2014, and the opposite party number 2 paid a sum of rupees 10 lakhs as earnest money. With Mrs. Bal Gopal, there was a direct sale.
Ma'am.
There was no agreement for sale.
No agreements.
Okay. Subsequent thereto, Nomita Agarwal, complainant, entered into an agreement with Image Vincon Private Limited. And an amount of rupees 10 lakhs was paid by the company to the complainant. The allegations in the complaint precisely is that the opposite party, sorry, the petitioners failed to make payments of rupees 10 lakhs is the 10 lakhs to the complainant. However, the records will suffice that such amount of rupees 10 lakhs has been adjusted at the time of execution of the sale deed. Stop. The entire dispute between the parties is relates to non-payment. If any relates to non-payment, and there was no deceitful act on the part of this opposite parties, petitioners in the transaction which has taken place by way of a deed of conveyance on 8th January 2015. The issuance, therefore, the ingredients of section, in which section the cognizance has been taken, under section 420, 406, 409, 422 and 34 of the Indian Penal Code, is not attracted in the facts and circumstances of this case. He seeks for stay of the proceedings. Upon going through the records, it is found that on June 2014, the complainant entered into an agreement with accused number 1, Srimati Padeshwari Rai, and paid a sum of rupees 10 lakhs to accused number 1. Thereafter, the complainant entered into an agreement in the month of July 2014 with one Image Vincon Private Limited. Upon payment of rupees 10 lakhs. The deed executed in favor of Mrs. Bal Gopal, tell me the name.
No, Cosmo Sales Private.
Cosmo Sales Private Limited.
Cosmo Sales, man. I stand corrected.
Cosmo Sales Private Limited shows that the who is your vendor? Padmasri. Padmasri. The amount of rupees 10 lakhs has been paid to the vendor by the complainant Nomita Agarwal. Therefore, in view of such materials, this court finds that an arguable case has been made out on behalf of the petitioners. Petitioners are the directors, who are the directors of Messrs. Bal Gopal. Next line. Accordingly, the civil criminal revision is admitted, issue notice upon the opposite parties. State is a party?
Yes.
Yes. Opposite parties. According, there shall be stay of further proceedings in CR case number 219 of 2016, pending before Judicial Magistrate Third Court Siliguri for a period of 6 weeks or until further order, whichever is earlier.
Grateful, Lordship.
Good.
Parties shall be at liberty to pray for. Petitioner is directed to serve notice upon the Additional Public Prosecutor, Circuit Bench of Calcutta High Court at Jalpaiguri, in the office of, and also serve notice upon the opposite party number 2 through registered speed post with acknowledgement due and file affidavit of service on the returnable date. Place this matter before the next available circuit bench.
After 6 weeks, Lordship.
Yes, it will be listed before the stay is for 6 weeks. Matter will be listed before the next available circuit bench.
Lordship, grateful.
But the next matter is also against the same complaint, but the petitioners before the lawsuit are different now. The petitioner are the witnesses to the same thing.
Witnesses.
The husband and son of Padeshwari.
So again, the witness, the summons have been issued.
Padeshwari is no more. In fact, complaint was actually against Padeshwari and the 2 witnesses.
What is their name?
Their name is Kailash Roy and Kiran Chandra Roy. Although there is no specific allegation against them in the complaint.
Where is the order of the trial court?
Is the certified copy, Malad? After page.
No, trial court, I mean the Judicial Magistrates Court.
Malad, that has not been annexed, Malad. If you kindly grant me liberty to file a supplementary affidavit this regard. To annex the copy of the file.
I have to see that whether.
But from the judgment impugned, from the impugned judgment, Lordship will get the name of the 3 persons.
They have also preferred a criminal revision, Malad, against
After page number 51.
Do you have a copy of that?
No, I'm not holding that. I tried to obtain it, but I have not yet obtained it.
With the order of the trial court.
No, the order of the trial. I could not obtain one. A certified copy. Because it was filed with the revision, Malad.
Mr. Navankur Pal, learned advocate, seeks leave to file supplementary affidavit annexing the order dated 7th April,
Malad.
7th April 2016,
2016.
passed by learned Judicial Magistrate Third Court Siliguri. Leave granted. Please this matter before the next available circuit bench.
Grateful, Lordship, grateful.
To serve a copy upon notice upon the state. There is a delay of application for condonation of delay there, my lord. If that can be disposed of, my lord, I can again serve it to the accused husband. So that, my lord, it could be finally decided, my lord. Without his presence, my lord, it would be.
So to serve copy of one. This is delay in
My lord, technically there is no delay, but since an application has been filed, taking 30 days as the period for limitation, my lord, but if 90 days is taken, my lord, it is within time.
this is against which order?
My lord, the order wherein the London district judge has affirmed the order of acquittal under the case of 498A and other provision.
Dismiss.
Lordship,
Oh.
item number 3. Condonation of delay. Delay আছে.
What is the limitation period?
It's not within the time, but the application is.
No, no,
filed.
what
That
is the
I-
limitation period for 482 application? Is there
No,
any
there is
kind
no
limitation? Then why this limitation application?
Because that is a general practice, my
No,
lord.
that
Because if there is
cannot
some
be,
delay, the.
482 applications we have not seen.
But
Yes.
that's what I.
The lawyers are filing itself. When there is no specific limitation prescribed under the limitation schedule to the limitation act, what is the purpose of filing an application
And
for condonation of delay?
3 years.
Within
What?
that.
This is an application. No. Bosun.
What it will do.
There is no limitation for 482.
My lord, 90 days. My lord, any application before the Honorable High Court has to be filed within 90 days.
That is within 90 days.
Within 90. Order was filed, judgment was passed on 29th February 2024. Instant revisional application has been filed on 20th May 2024. Within 90.
Okay.
I don't think 483 also applies for 482 applications.
Hmm.
482 for limitation of one and one. Therefore, আমি confused হয়ে যাচ্ছি।
Provision করি না। তুমি কি provision?
Provision.
কি provision করতে পারি?
You are withdrawn the application.
My lord, the condonation. I cannot place that.
We get into the contents and merits of the application.
Merit of the application, my lord, this is an application against two acquittal orders, under 482, against two acquittal orders, one by the trial court, another by the first appellate court. There is no provision of second appeal, it's an appeal against acquittal, my lord. There is a double presumption of innocence, number one, my lord. While admitting this application, the certain criteria are necessary, to be considered. Those criteria are the same criteria which have been laid down by the Supreme Court while considering various cases arising out of acquittal, appeals from acquittals. One, primarily there is a double presumption of innocence in favor of the accused, number one. Number two, my lord,
Yes, let him submit.
Yes, madam.
Let him submit it.
the two questions, just two questions, my lord. After that, I will take your lordship's leave and my junior friend will be here. My lord, number one, he has to show that the judgment of acquittal suffers from the patent perversity. Number one, two courts are there, lordship. The judgments, he has to show the judgment suffers from patent irregularity. Perversity, lordship. Thereafter, number two, judgment is based on misunderstanding or omission of evidence already on record, lordship. And number three, if two views are possible, lordship, like similar, it is applicable in the trials also, two views are possible. If there is the evidence leads to the sole conclusion, only conclusion, leading to the guilt of the accused, in that case, only a order of acquittal can be overturned. So he has to satisfy primarily these three things before admission, in my humble opinion, lordship. Yes, your lordship consideration. This is my view, sir.
Yes.
The presumption of innocence is high now.
That is for the accused person to say, madam, not the state. And
The state,
the
the
state is
accused is
making
also
such
the state,
comment
the state has a
because, my lord, what I
responsibility.
have pleaded
Sorry,
is
sir.
collusion.
Sorry,
The
sir.
entire time, my lord, the petitioner hearing was being, the petitioner had taken the assistance of district legal aid services.
Sorry, sir. Madam, one thing I must clarify.
No.
My junior friend. Sorry, sir. State, the accused is also a subject. State
Yes,
subject.
yes.
The
Sir,
state
let
has a
me-
responsibility to ensure that everyone should get justice.
Yes.
So I cannot keep my eyes closed for the fact that he is the accused. No, sir. My
So,
duty
my lord,
is
may
to
I
assist
please
your
agree,
lordship
my
with the unvarnished truth.
My lord, the entire case, my lord, this petitioner has suffered because of collusions between the advocate of the petitioner herself, my lord. The evidence that are on record that has been adduced by the PWs. My lord, the learned advocate who was appearing before the trial court has not submitted a vital piece of document that was supplied to him. And that was the complaint based on which the initial action has been complained of. But that was never taken on record, my lord. And if that complaint is taken on record, my lord, the entire facts narrated by the PWs will be corroborated and the acquittal itself will be turned aside, my lord. That is my case, my lord. The entire case, my lord, the learned trial court, while considering, could not be placed with a complaint that was earlier lodged by the complainant before the police. But police, instead of registering that as an FIR, had brought the accused before the police station, and police themselves had initiated a negotiations, and they had even fixed a amount for maintenance, that the accused will pay this maintenance to the complainant, and based on which the complainant then did not press further on the criminal charges at that point. But that complaint that was received by the police was never placed before the learned trial court to consider the veracity of the truth that was made. And the acquittal is just made on this point, that the complainant did not submit any document showing that there was a previous complaint before the complaint based on which the FIR has been subsequently registered. My lord, the earlier complaint was registered in Darjeeling PS, Sadar PS. Subsequently, based on the intervention of the family members and the police officers, that complaint was not acted upon. The accused started giving maintenance to the complainant. After which it went on for a certain period of time. Then again, the violence and the torture was inflicted upon the complainant, and the complainant thereafter had to lodge the complaint based on which the proceedings had been initiated, my lord, at Kalimpong. My lord, may I take, my lord, to the case that was earlier, that is that page number, complaint, my lord, that is the complaint, annexure B.
Beyond the record.
No, annexure B is the complaint that is registered.
It has a limitation. My lord, in the cross examination, kindly come to the cross examination of PW
Sir,
one.
let me submit, sir, first.
No, I get point. I'm helping you, sir. What you have said in the cross examination is there. Even if that is brought on record, the subsequent FIR is hit by the judgment of TT Antony versus State of Kerala 2001 Supreme Court. So
Okay, that I be satisfied. That was never placed before the court when the trial court passed its first judgment. The trial court office was of the view there is no corroborating document. But that is not the lapse of the petitioner. That was the lapse of the conducting counsel for the petitioner. Though the petitioner had that document and had given it to the learned counsel, despite that it was not given and submitted before the court. Marriage, it has paid 22. This is the complaint based on which the present criminal proceeding had been initiated.
Yes.
But the date of marriage is at para 2, 10th October 2018. It was a love marriage. That father-in-law this resided with us and never happy with our marriage since its inception because he wanted a more qualified, intelligent and mature daughter-in-law. However, I tried every possible means to be good. After a few days of marriage, my husband went to his job and he was in the Indian Army. And in his absence, my father-in-law used to quarrel with me on trivial issues and flimsy grounds and used to torture me physically and mentally and ask me to bring money from my parental house and used to taunt me by saying that I am not his choice. His son could have found a more beautiful, qualified girl than this. Thereafter, whenever my husband came to home on leave, my father-in-law used to start bad mouthing about me and my husband that this. Then my lord Kyler takes para number 6. Now, this is how it has been narrated, my lord. Then thereafter, my lord. Para 10 is very important, my lord. On 8/6/2019, I went to Women PS station Darjeeling for lodging a complaint. But they called my husband and asked me to give him a chance and to our matrimonial life, and they asked us to solve the matter amicably. Accordingly, my husband assured me that no further torture would be imposed on me by him or his father, and my husband all assured me that he will lead a happy matrimonial life with me and will provide all the basic needs. And upon this, somewhere in the first week of July 2019, I received a lawyer's notice which was sent on behalf of my husband asking and requesting me to come back to his house at home. To which I even replied through my lawyer that I shall go to his house provided he stays separately from his parents. Because I did not want to stay with my in-law, especially with my father-in-law, as he was the main mastermind behind all the pain, torture, both physically and mentally, and ill treatment and trauma has started. And of course, my father-in-law also provoked my husband against me, which aroused hatred against me. After such persuasion from my husband, I went back to my matrimonial house on 2nd September 2019. Thereafter, everything was okay and I was very happy. With the passage of time, I came to know that I conceived through a pregnancy test kit at home and informed the news to my husband and father-in-law, but they were not happy. My husband asked me to go for abortion, but I refused to do so. And on refuse, my husband got angry and tortured and started abusing me again by him and his father. Then my lord, para 30. After getting to know about the loss of innocent life, in the month of May 2020, I was chased out of a matrimonial house by my husband and father-in-law. It was the peak time of lockdown. I somehow managed to go back to my parental house at Kalimpong. In the month of September, when started returning normalcy after lockdown, because I got a job offer in the Pune, and I had applied online. So accordingly, I went to Pune, and pandemic broke out again. She had to return. I returned from Pune on this to meet him and discuss the probabilities of finding a solution for a good and happy marriage and settle down with you. But to my utter surprise, my husband had already filed a divorce case against me in the Darjeeling.
They have been
being-
divorced.
My lord, that decree has been challenged. My lord. It is under review.
Decree also challenged.
My lord, the entire decree has been passed based on this complaint, my lord, that since he was acquitted in the complaint, so this amounts to cruelty. That I have lodged a false complaint against the accused persons. My lord. Now, my lord, lodging false complaint has not come up.
Now I understood the Hyderabad's application.
Anyways, my lord, that divorce application is not maintainable, my lord, because it was granted under Hindu Marriage Act, and by law it is barred, my lord. The complainant is a member of scheduled tribe community, my lord, and Hindu Marriage Act is not applicable in that case.
This you have stated in a written statement.
No, my lord, that is the point of law, my lord, that is before the.
No, you didn't
in the first.
challenge the maintainability of that application. That
My lord,
You are not there.
My lord, I would not want to make such comment, my lord. In the trial court, my lord, the learned advocates have not represented the case as it should have been done. My lord, and for that, my lord, the mistakes and lapses on the part of the advocates, my lord, a petitioner or a complainant should not suffer, my lord. This is a settled law.
Every complaint will go for a de novo trial.
My lord.
Because somebody has to have some redressal and grievance
No, my
if
lord,
any of the judgments
My
pass.
lord, if there was a case of falsity, my lord, there would not have been document to show that. But my lord, in this present case, my lord, there are documents that are.
Submissions in every application, if not satisfied, then they will go for a de novo trial.
My lord, my submission here is, my lord, if I had not had a document to corroborate with my evidence, then it was not the case. But in this case, my lord, there are medical documents that were not placed. The documents are not today's date, my lord. It is of the date of the relevant time. It was just not placed before the learned trial court, my lord. If these documents are placed, my lord, the fate of the trial would have been very different, my lord.
Anyway, yes.
So, my lord, based on this, a charge sheet was submitted, my lord. Based on the complaint made by the.
Now, which was the complaint that was not taken into consideration?
My lord, the complaint that was lodged in the year 2019. That complaint is, my lord, I have annexed.
Page number?
My lord, kindly take page number 87, my lord.
Page number 87.
Yes, my lord. It's a general diary book. 8/6/2019. This time, one Srimati Priya Tamang, wife of this of Hasmal Basti Sukna Road, reported creating mental torture, and she was in this regard called off, and this both the parties decided to stay away from this.
Did you find a 391 application before the appellate court?
In this regard.
391 application, did you find?
There
There is a provision under section
That
391.
was not done, that is, it was
it is to note.
after by DLS. And this, when she went with the complaint, my lord, recording this general diary, they were asked to go back. My lord, my lord, I have also.
It's not that they were asked to go back. It
My
is that you and the husband both have agreed,
That is
and
by
Priya, what is
coercion, my lord. They
Priya
were
Tamang
compelled.
didn't want, it is recorded, didn't
Yes,
want
did
to
what?
file any case against her husband.
My lord, the complainant went with a complaint, but the police, because my.
See, one thing is that both the parties agree to file a mutual consent divorce.
Yes, ma'am.
They come up before the court, swear affidavits, and the court take into consideration grant a
30.
mutual consent divorce.
Yes.
Thereafter, a case application is filed that this is not the case. The agreement or what has been agreed between the parties, it is not the actual fact. This is what has gone into.
But this
In
has,
general diary, it is recorded that you have agreed not to lodge any complaint against your husband.
because of the assurance that he will not further.
But I will
inflict
require you. Yes, you can leave now. If required, you come back.
Lordship.
My lord, my commission, this was based on the police's act. They have done a very good thing to try to resolve the matter amicably. But my lord, there was a torture and there are documents to show that there was torture at this point when she reached the police station. But my lord, I'll come to the trial court's findings. My lord, the trial court has not considered the PW1 and PW3. They are corroborating. The court asked whether he have lodged any complaint. He has said yes, but only that was not produced before the trial court. If that complaint was produced, then the court would not have come to this finding that the court has come. And page 92, it is the commissions made that he will give monthly maintenance and they will not torture, my lord. Both of them have signed this.
Where is your memorandum of appeal? Where is the memorandum of appeal?
I missed this. May I be permitted to file a supplementary tomorrow? Supplementary or I will have certified copy.
Other documents, all are there, evidences and all.
Yes, my lord. I've annexed the charge sheet.
Throughout the trial, any application was filed for additional evidence? No.
No, my lord. No steps were taken by the learned advocate for the appellants, my lord. My lord can see if the records were called for. It is conducted in a very haphazard and a very. It would not.
Did you file any application before the learned Chief Judicial Magistrate
For
for your grievance of any investigation not been conducted in a proper manner?
and those steps were not taken.
After the results come out, you come up with an application for a de novo trial.
My lord, the circumstances
was
has
the-
brought the
You
petition.
file that memorandum of appeal.
Yes, my lord.
You have a copy of that? Mr. Amit Singhal, no? Ajay Singhal, learned advocate for the petitioner. Seeks to, you check your memorandum of this revisional application, whether any other document is required to be annexed for the hearing. Seeks accommodation to, seeks leave to file supplementary affidavit annexing the memorandum of appeal. In what is the appeal number?
Appeal number 7 of 2023.
7 of 2023 before the learned,
Additional district and session.
the additional. No, this is Sessions Judge Kalimpong.
And it was subsequently transferred to the additional.
No. The judgment says Sessions Judge at Kalimpong. Sessions Judge. Before the learned Sessions Judge Kalimpong. Leave granted. এই 29th দেখুন তো। 29th. Is this matter on 29th? কি বলছো? Admission এ? Oh, ঠিক আছে, 29th.
Item number 4, I have for the state, your lordships. This is a very interesting case that the
None appears on.
petitioners filed this case
Huh.
for quashing the application. There is a two applications. One is NI Act, another is 1/420/406, and a totally different cause of actions. That's why the learned Dinata ACJM turned down their prayer, and the case was instituted. And the fine was imposed against the accused petitioner. And being agreed with that order, they prefer this revision applications, your lordships.
This is order of acquittal.
Yes, yes.
This is against which order? Order.
Against order lordships, page number. P4, your lordship, page 19, their application.
Modern judgment dated.
Lordship got it, lordship?
Just wait, just wait. Affirm.
Actually, Lordship, their contention is that the only one case be instituted against that one person's. No person
That
shall.
is a separate case.
Yes, Lordships.
That's no revision is lying against that.
Yes, your Lordships. So they have filed only to drag the proceedings, my submissions, your Lordship.
Where is the order of the trial court?
Lordships, order of
10-9, yes.
the, Lordships. Last portion, page 24, your Lordship. Lordship, page 23, last portion, the findings of the trial court already given their reason why. That's because both the cause of actions are different, so there is no bar to take cognizance under section 420 IPC, Lordship.
138.
Yes, Lordship.
This is against 138.
138 and another. They said ki when the one case is pending 138, so it will be take only one matter. Amalgamate with that petition, your Lordship.
Who is the complainant in the case under 138?
Complainant, your Lordship. Hafizul Khandar, Khandakar.
Uh,
Sorry, Arjuman Bibi, wife of Hafizul Khandakar. Annexure P1, Your Lordships.
Hussain.
Dinata specific case has been registered under section 406, 420, 34, Lordships.
In that case, the accused persons have been acquitted.
Yes.
This is an application for washing of judgment and washing or setting aside. Judgment and order dated 19th November 2024. Passed in criminal revision number 7 of 2024. বাইটা আগে দেবে না passed by learned additional sessions judge Dinhata Kuchbihar in criminal revision number 7 of 2024, affirming order dated 10 September 2024, passed by learned additional chief judicial magistrate Dinhata in CR case number 106 of 2020, dismissing the prayer of the petitioner under section 210 of the Code of Criminal Procedure, within bracket in short CRPC. None appeals on behalf of the petitioner. On repeated calls. On the previous date, that is 20th January 2025, the petitioner was not represented. In the aforesaid backdrop, the present revisional application is taken up for consideration and disposal on merits. The brief fact of the case is that a complaint case was initiated by one Hafizul Khandakar against the petitioner under section 138 of the Negotiable Instruments Act, within bracket in short NI Act, for dishonor of check. On the contrary, the wife of the present petitioner, namely Najma Khatun Bibi, lodged a written complaint before the before the
Bashir Dinhata police station.
before the Dinhata police station under section
406, 420, 34.
406.
420 lordships,
No, 420. 452.
lordship, annexure P2 lordship there. First information report lordship. Lordship, 471, PPS 400, 406, 420, 34 IPC, SI Ajit Kumar Shah for investigations.
Dinhata police station case number কত বললাম বলেছি 460 of 2020. And charge sheet was submitted under section 452, 352, 384 and 34 of the IPC. এই দিনহাটা পিএস যেটা আছে না corresponding GR case number পর্যন্ত ব্র্যাকেটে GR case number 531 of 2020. An application under section 210 of the CRPC was filed for filed by the petitioner. In CR case number 106 of 2020. For trial of the complaint case along with GR case number 531 of 2020. This will not be moved since the petitioner has already been acquitted. Then the opposite parties have been acquitted in the other proceedings. And both shall be tried together. Such prayer was rejected by the trial court. VD order dated 10 September 2024. Judgment considered. Twenty 2020. The order of the trial court was challenged in revision before the learned additional sessions judge Dinhata. The order of the learned trial court was affirmed. Being aggrieved by and dissatisfied with the impugned order, the petitioner has preferred the present revision application. এই আমি একটু 12টা পরে নামবো, হ্যাঁ একটু পরে আবার উঠবো। হ্যাঁ revision. On going through the
Opposite party number one. Okay.
record করুন। Mr. So-and-so, learned advocate for the state as well as opposite party number 1, submits that there is no question of double jeopardy. Both the cases have been initiated on the basis of separate cause of action. And as such, the order of the learned trial court as well as the revisional court should be affirmed. Upon perusal of the order of the learned trial court, it is found that it has categorically held that the offenses in CR case number 106 of 2020 and the offenses in GR 531 of 2020 are distinct and separate. And the question of application of principle of double jeopardy or rule of estoppel does not come into play. The learned revisional court has also held that the ingredients of both the offenses are separate and distinct. and the offenses of both the cases cannot be construed to be arising out of same set of facts. Upon perusal of the records, it is found that a case under section 138 of the NI Act registered as CR case number 106 of 2020 has been initiated against the petitioner. The wife of the petitioner lodged a criminal complaint before the local Dinhata police station, and charge sheet has been submitted under section 452, oblique 352, 484 and 34 of the IPC. Such being the position, the offences are distinct and separate. Both the trial court as well as the court in revision has rightly held that the offences are separate and distinct, and there is no question of double jeopardy. Accordingly, this court finds no merit in the application. This court finds that the orders passed by the trial court and the revisional court does not call for interference. Accordingly, criminal revision falls short of merit. Hence, is dismissed. On connected applications, going to put it. Sorry about it. Yeah.
Only by name field. This was a name field.
You must, the time when the matter is being called, you don't appear. Can you issue dictation?
By name field. This was a name field.
Oh, you behave নিয়ে এসে মনে হয়। Give your name. এ নিয়েছে, মিঠুন বাবু নিয়েছে মনে হয়।
Number five.
My lord, five and six may be taken up together. Item
Ah.
number five happens to be the counter blast of the item number six.
Ah.
It's a counter blast FIR, my lord. On the last occasion, my lord. May I, my lord? Yes, on the last occasion, my lord, you were asked to bring the both the complainant and the petitioner of both the cases. Both are present. Both are present. And a judgment, we were asked to bring a judgment as to where a non-compoundable offense may be compounded and be quashed. We have both the things, my lord.
Item number 5,
Yes, my lord.
17.
Yes, 17 and 18 both.
No,
Sev-
no, 17.
Very good.
What are the offenses alleged in item number 17? Item number 5?
Item number five, my lord, offenses are 115 1,
115 1,
125 B, 281, 35,
281,
281, then my lord, 3 subsection 5.
281 3 subsection 5.
281 slash 3 subsection 5. The next section is 3 subsection 5. And the other section is my lord 351 1.
1.
My lord. My lord, here, this happens to be the counter blast of the item number 6, my lord. Whereby, my lord, the other side is ready, Mr. Shubham Chakraborty. He is the, one second. Yes, yes. He is the complainant in this section, my lord. He is ready to compromise it, and we have filed and grant along with this revision. application.
Hmm. 115.
Yes, yes, yes. Yes. See, there is a marking.
125 to 35. Only 35. 115 1. Voluntary causing hurt.
Very good. Thank you.
Hurt. One 25. Okay. Acting in life. We got doesn't even endangering him. 50 other people is 125B. Which is the corresponding provisions of compoundable offenses? 320 corresponding? 320?
T20
That is the old CRPC. The new one?
359.
Compoundable. 125 2. Non-compoundable. Okay, then. Next is 81. Reverse 125D compoundable. Double summary. Gravy. Reverse compoundable. Compoundable 281. One C. Non-compoundable. 351. Only one is non-compoundable, that is 281.
Yes, ma'am.
281. Was he hit by any vehicle?
There was a collision, my lord. There was a small collision and and subsequent there was a fight. And after 59, I'll tell you, my lord, after 57 days, the FIR were lost and after that, all those rage gone
Okay.
down.
This is one.
Yes.
Which one is the other one? What are the sections?
My 125 B and 81, my lord.
125B compoundable and 21.
21.
281.
Yes.
Okay.
My lord, even asked for certain judgment.
What is this?
My lord, for judgment, my lord has asked us to whether non-compoundable offense may be compounded on. কোনটা? না, 125 আর 280 বলে আপনাকে। Yes, madam. May I know? It's okay.
Yes.
Hello. This is order.
I just show you this. Jian Singh has been quoted in one judgment. You have to look to this.
My lord, which page I am telling?
Page 67. Says that it has a only in cases where the offenses are not private in nature, have a serious impact on the society, those cannot be compromised.
Right.
So this is not that case.
What is the?
Okay. Ashwin, 5. This criminal revision has been filed.
Thank you.
Challenging for washing of proceedings being GR case number 137 of 2024 arising out of Karsiang Police Station case number 136 of 2024 dated 29th August 2024 under sections 115(1)/125B/281/3 within bracket 5. Hmm. What is section 3.5? 3.5. P5 slash 351(1) of the Bharatiya Nyaya Sanghita 2023.
That is not going to 34.
Question বার করতে গেলে তো 3.5 taken. The fact of the case is that the federation মানে it may be done seven for the final function 3.5. Okay. That the opposite party number 2 complainant lodged a written complaint at Sukhna Investigation Center on 24th November 2024 that on alleging that on 29th September 2024, while he was proceeding towards Rongtong from his residence near Sukhna Mode, he met with an accident with a scooty bearing number WB74 AU8208, which was recklessly driven without any helmet and indicator. Stop, the rider was a minor. Due to the said accident, he sustained injuries. On the basis of such complaint, FIR was initiated at Karsiang Police Station, being Karsiang PS case number 136 of 2024, dated 26th November 2024 under sections গুলো দিয়ে দেবে না? Mr. Shaturudra Mukherjee, learned advocate appearing for the petitioner. In this case, you are the for the petitioner?
Which is
Five.
five, no, my lord, Ms. Usmita Mukherjee.
Miss Usmita Mukherjee, learned advocate appearing for the petitioner, submits that the dispute by and between the parties have been amicably settled out of court. Relying on the decision of Honorable Supreme Court passed in Jian Singh versus State of Punjab, reported in 2012 volume 10 SCC 303. He submits that since the matter has been settled by and between the parties, the proceedings should be quashed. As against the petitioner to prevent abuse of process of the court. Mr. Shaturudra Mukherjee, learned advocate for the opposite party number 2 complainant, also concedes to the fact that the matter has been amicably settled by and between the parties. Mr. Shubham Chakraborty, who is opposite party number 2 complainant, আপনি এখানে অ্যাপ্লিকেশন ফাইল করেছেন? আপনাদের মধ্যে ডিসপিউট মিটে গেছে? Mr. Shubham Chakraborty, opposite party number 2 complainant, is present in court, and he also informs that the matter between the parties have been amicably settled. To that effect, one application has also been filed for submission থাকবে, being CRAN 1 of 2025. Mr. Niloy Chakraborty, learned advocate.
Number 5, that is number 6, sir.
Mr. Aditi Shankar Chakraborty, learned additional government public prosecutor, submits that, bearing in mind the offences alleged and the proposition of law laid down by Honorable Supreme Court in Jian Singh Supra, there is no impediment in quashing the proceedings. From the materials on record, and also submissions advanced at the bar, it is found that the dispute by and between the parties have been amicably settled out of court. The FIR has been initiated under sections দিয়ে দেবেন। The offences is not heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. The Honorable Supreme Court, in Jian Singh versus State of Punjab, in Jian Singh Supra, Jian Singh Supra observed as follows. এখানে এই প্যারা পেজ 66 এই কোট করে দেবেন এটা আগের এতে জাজমেন্টে থাকতে পারে একটু চেক করে নেবেন এটা জিয়ান সিং, এই যে 9 প্যারাগ্রাফ 9 61টা, হ্যাঁ দাগ দিয়ে দিয়েছি। Bearing in mind the proposition laid down by the Honorable Supreme Court and also keeping in mind the facts and circumstances of this case, the proceedings pending being number such and such আগে থেকে নিয়ে নেবেন, pending before which court? হ্যাঁ, pending before Karsiang, this is SCGM? Pending before Chief Judicial Magistrate Karsiang, Additional Chief Justice, SCGM, ঠিক আছে। Additional Chief Judicial Magistrate Karsiang, Darjeeling, stands quashed. The CRR number 17 of 2025 along with PAN 1 of 2025 is allowed and disposed of. সেম ওটাতে সেম অর্ডার, শুধু এখানে সেকশনসটা আলাদা হবে, এখানে সেকশনসটা হচ্ছে ইয়েস, ওখানে স্টেটের কাউন্সিলটা চেঞ্জ হয়ে যাচ্ছে। এখানে শতরুদ্র, মিস্টার শতরুদ্র মুখার্জি ফর দি পিটিশন, পশ্চিমিতা মুখার্জি। And what is the name of the complainant? বিকাশ প্রধান। আপনাদের মধ্যে সেটেলড হয়ে গেছে এটা? हो गया? ভেরি গুড। সেম হবে, বিকাশ প্রধান শুধু অ্যাপিয়ার প্লিজ। 6 নম্বরে না মিস্টার নিলয় চক্রবর্তী ফর দিস টু।
My lord, item 7, my lord, I am for the petitioner.
For state,
Lordship, I'm on behalf of the petitioner Lordship. Advocate Deeptangshu Basu will be appearing before your Lordship. Lordship.
I am appearing for the petitioner, my lord.
Hmm.
My lord, I have challenged an order of refusal of cancellation of bail of the opposite party number 2. What has happened, my lord? A case was initiated under section 406, 417, 420, 323, 506 of the Indian Penal Code. And the allegation is that, my lord, the opposite party number 2 had approached me to supply premium tea. Accordingly, during
Supply?
6th of for supply of premium tea, since I am a proprietor of a tea company, my lord, I have been approached by the opposite party number 2 to supply tea to him. The supply was made from 6th of March 2020 up to 18th of January 2021 to the tune of around 28 lakhs. My lord, subsequently, even after the handing over of the entire consignment, my lord, no payment was made. 3 checks were issued, but due to insufficiency of fund, that was dishonored. The accused obtained bail on the ground of compliance of 41A notice. Subsequently, what has happened? He was granted bail on 16th of February 2024.
order
My
of
lord, my lord, order is at page 20, my lord. The bail order is at page 20 and Excel P2.
তাপস সিংহ।
He was granted bail, my lord.
Hmm?
My lord, thereafter, this accused went into the office of the
Page 20 is the bail order of Taposh Kumar Singh.
my lord, he is the opposite party number 2 accused. I am the complainant.
Okay. You are the
Uh,
complainant.
I am the complainant. my lord.
Okay.
He was granted bail on 16th of February 2024. My lord, what has happened thereafter, my lord? The accused went to the office of this petitioner on 10th of April 2024 and threatened the staff as well as the petitioner with dire consequences and to withdraw the FIR against him. My lord, the petitioner immediately went to the police station and lodged a general diary, and there on 10th of April 2024. My lord, this complaint is not annexed with the petition, but your lordship would find the reflection at page 21, annexure P3. The petitioner thereafter filed a application for cancellation of bail on 18th of April 2024. And even the state had applied for cancellation of bail of the accused person, which is at page 21. The relevant part your lordship would find at the bottom, page 21 at the bottom.
Please, I am okay, of speech, man. Need to do office of community examining. Yes.
Well, thereafter, the state, for reasons best known to them, they had withdrawn the application for cancellation of bail. But as the petitioner had on 18th of April filed an application for cancellation of bail, my lord, during the pendency of that application, my lord, although charge sheet was submitted on my lord 30th of April 2024, but cognizance of the charge sheet was taken on in January 2025. And there were, during the pendency of the cancellation of bail, my lord, 11 adjournments were taken by the state, 4 adjournments were taken by the opposite party number 2, and subsequently the matter was disposed of only on 16th of December 2024. My lord, there is a erroneous finding in the impugned order, my lord. It says that the present application for cancellation of bail has been filed by the informant company on 18th of April. That is after a lapse of more than 2 months. My lord, I had immediately taken steps after the lodging of the general diary against the petition against the opposite party number 2, and had taken steps to file this cancellation of bail. It was the lacuna on the part of the state that they had sought for adjournments on 11 occasions, my lord. Thereafter, even the cognizance was taken 6, almost.
Where is the application for cancellation of bail?
My lord, cancellation of bail has not been, the application has not been annexed. If your lordship desires to get the copy of the, may I file a supplementary affidavit in that regard?
Who is for the state?
It is happening for the first time.
State mother, but even then, senior appear as city is required. So therefore, cancellation of the bill.
Mr. So-and-so learned advocate appearing for the petitioner through virtual mode seeks leave to file supplementary affidavit annexing the copy of the application.
Well, along with the, my lord, may I also annex the copy of the complaint which I had filed subsequently, along with the application for cancellation of the.
The main things, these have not been annexed.
My lord, I know, my lord. Kindly allows me to file a supplementary affidavit annexing all the relevant documents, including the copy of the petition of cancellation of bail.
Any application was filed before the CJM for cancellation of the bail?
CGM actually has granted the bill. It was to be
Before the sessions.
Sessions go, but it was rejected.
18th of April 2024, it was filed and disposed of only in the month of December 2024. And cognizance was taken of the charge sheet in January 25. The same was submitted on 30th of April 2024.
What is the position of law that it has to be filed before the court which granted the bail or to the higher?
Cancellation, if legal petition is that, my lord, it is court. If there is a violation of the bail condition, then that same court can cancel it. Or if there is question regarding the propriety, then the validity of the order itself is under challenge, then that is a higher.
No, they are making out a ground that there is some violation of the order passed by the CJM. Which forum the cancellation application is to be filed? Suppose a condition is imposed. Suppose to meet the IO once in a week, if that is violated, then the cancellation comes to the court which granted the bail. Then here, what is the ground taken for cancellation of the bail?
The subsequent threatening of the petitioner.
Then
The violation of permission.
no cancellation of bail has been filed before the CJM, but a application of revision under 439(2) comes up before the Sessions Court. So Sessions Court, how can the Sessions Court say scene of the matter? Until and unless an application is filed before the CJM seeking for cancellation on such and such ground. Because the propriety of the order was not challenged. They accepted it. Now there is a change in circumstances of threatening, muscle power, etc. Okay.
One point I need to submit.
Please, sir, your senior is submitting in virtual mode. He is hearing what we are discussing. Please don't come and intervene between. What you do is, you file your supplementary affidavit annexing the application filed before the sessions judge.
My lord.
And what is the other one? The complaint before the police.
The subsequent complaint before the police.
Annexing copy of the application being criminal mispetition number 3 of 2024 before the learned Sessions Judge Jalpaiguri and the complaint made before the police. আচ্ছা ওইটা না ওই পিটিশনটা যেটা বললাম ক্রিমিনাল পিটিশন আন্ডার সেকশন 439(2) of the CRPC for cancellation of bail. The 6 leave to find supplement. Leave granted. Mr. Chakraborty, produce the case diary on the returnable date. Mr. Niloy Chakraborty, learned advocate appearing for the state. Give a copy to Mr. Chakraborty. Appearing for the state. Huh? ও তো বলছে appear করছে। Appear করে যাচ্ছে। Mr. Chakraborty, any order is required for regularization of your appointment? Mr. Niloy Chakraborty appears on behalf of the state of Mr. Aniruddha Biswas administrator appears on behalf of the state. Let the appointment of Mr. Chakraborty and Mr. Biswas be regularized by the concerned authority. Mr. Chakraborty, learned advocate representing state opposite party, submits that the case diary will be required for hearing of the matter. Let the case state opposite parties directly produce the case diary on the returnable date. When, sir? 29th, 30th, which date? 30 তারিখের on 30th.
Item number 8, Lordship, I'm appearing for the petitioners.
Not yet called. Not called.
Sorry, my lord. Sorry, my lord.
Yes.
So item number 8, Lordship, I'm appearing for the petitioners, Lordship. Today is for the, it's listed under the heading extension of interim order. Lordship, the, or the interim order was granted, and I'm praying that it may be extended further and at the date for hearing may be fixed, Lordship.
And 3.
It's a transfer application of a 107 application, Lordship. I'm the wife. My husband has made 107 against me, Lordship. There are several proceedings that are initiated before this Barrackpur court, Lordship. And I'm praying for transfer of the said application to this court. The order may be extended, Lordship, and date of hearing may be fixed, Lordship.
Party number 2. My voice.
For transfer from India to Barrackpur. The fourth time the ready, then you can be heard with you.
Full learning.
He is appointed in the specialty hospital Coachbihar. It is not possible for him to appear in every single cases in every single day before the Barrackpur. It will be very inconvenient for him to take leave from his duty. My lord, we are ready to bear the expenses of ship in the petition has come and attend the hearing, my lord. We are ready to pay the expenses and the part numbers you have to take the office old.
I'm one, Lordship. I have a very minor child, Lordship.
Yeah.
For that, I'm praying for transfer, Lordship.
Lordship, I'm ready to pay
Child
the
of 2 years, Lordship.
child and the mother.
I have my ailing parents at my house, Lordship. I have to look after them, Lordship, and I don't have any source of income to go there and appear in that matter, Lordship. It may be done. The date of hearing may be fixed, Lordship. And till then, the interim order may be extended, Lordship. Any shortest possible date, Lordship. I'm ready for the hearing.
For the cash is a government doctor. Hospitals also, Lordship. In emergency situation, if the date is given at the court, my lord, then may not be possible for me to attend, my lord. That's why, my lord. There's already some cases are waiting over there. It will be very inconvenient. But it will be late.
In which court? Barrackpur.
My
You're going for attending those cases.
I think they have appeared in those matters. I have to take instruction regarding that, but as proper instruction is needed, but I think they have appeared in those cases also.
being a doctor, it is not possible for me to appear every interaction in every outcome in every case of lordship. It's very hard to solve.
Hmm.
Lordship, I have a child of 4 years, Lordship, and I have my ailing parents at my house, Lordship.
By stating the original
The husband never provided any maintenance towards me.
wait. Location is seeking transfer.
And this Lordship 107 proceeding is totally
Wait,
a
sir,
frivolous
wait,
proceeding.
wait.
Sorry, my lord. Sorry, my lord. Sorry.
What is the order? 30th November 2023.
It's a section 20, transfer for a section 24 application, Lordship.
And what is order dated 25th January 2024?
It's also a transfer application, I presume, of a criminal proceeding.
One is matrimonial suit and there is a guardianship case.
Yes, sir.
Oh,
Sure, sure, not clear. These two cases have been transferred.
sure. Along this petition. This will be before which court?
Land Court of Barakpur.
SDM Barakpur.
SB Barakpur.
This is an application seeking for transfer of MR case number 136 of 2023 filed by opposite party number 2 under section 107 of the লোক কোথায় গেল? তো একটু ভিজে গেছে যে দেরি হয়ে যাবে, দুটো হয়ে যাবে, দুটোর সময় ডিকটেশন দিয়ে দেবো, ঠিক আছে? এটা একটু শুনে নিয়েছি, তোমাকে বলে দিই। কন্টিনিউ, অসুবিধা নেই, ঠিক কি বললাম? 107 107 of the Code of Criminal Procedure, within bracket, in short, CRPC, pending before the court of SDEM Kuch Bihar.
And then maybe placed in the middle of the Barakpur and Kuchiyar, my lord, so that both the parties can travel and it will be easier for them, my lord. Because my
That will also be
Pending, বললাম, to the court of learned SDM Barak. Mr. So-and-so learned advocate appearing for the petitioners submit that petitioner number 1, she is the wife.
Yes, sir, Lordship.
Number 1 is the wife of opposite party number 2. And she has a minor child aged 4 years. Stop. For attending the court proceedings at Kuch Bihar. Sorry, for attending the petitioner number 2 is a senior citizen and other 2 petitioners are female. Stop. For attending the court proceedings, the petitioners are to travel about 2,500 kilometers The other cases, namely the matrimonial suit, being 97 of 2023 and guardianship case being number 14 of 2023, which was pending before the learned district judge Kuch Bihar, has been transferred has been transferred to the district judge to the district court at 24 Parganas North. Further, cases under sections. What is the GR case? Further, cases under section 125 of the CRPC and under section 498A 506 by 34 of the IPC is pending before the court at Barrack Court. In such circumstances, he prays for transfer of the instant case, being MR case number 136 of 2023, pending in the court of Subdivisional Executive Magistrate Kuch Bihar to the Subdivisional Executive Magistrate Barrackpur. On the contrary, Ms. So-and-so, learned advocate appearing for the opposite party number 2, submits that he is a doctor by profession and attached to super specialty hospital at Kuch Bihar. Kuch Bihar. If the in the event the instant case is transferred to Barrackpur, it will cause hardship in discharge of his function as a doctor. She seeks that the case be transferred to a district in between Kuch Bihar and Barrackpur, which will be conducive and convenient for both the parties. Mr. Chakraborty, what is your submission? Mr. Niloy Chakraborty, learned advocate for state opposite party number 1, leaves the matter to the discretion of the court. Admittedly, the matrimonial suit being number 97 of 2023 has been transferred to the learned district judge at Barashat. And the guardianship case number 14 of 2023 has been transferred to the district of Barrackpur from Kuch Bihar, from the learned district judge at Kuch Bihar. The other proceedings, namely proceeding under section 125 of the CRPC and criminal proceedings under section 498A, uh, 506 by 34 of the IPC is also pending before the court at Barrackpur. It has been categorically stated in the application that the petition number 1 has a minor child of 4 years. Petition number 2 is a senior citizen and the other petitioners are female. Considering the aforesaid fact and also keeping in mind that the other cases have already been transferred to the court at Barashat and Barrackpur, this court is of the opinion that the instant case being MR 136 of 2023 needs to be transferred to Barrackpur. Accordingly,
Most obliged, sir.
the application being CRR to what is Crano section? 194 of 2024 is allowed. The MR case number 136 of 2023 pending before the learned subdivisional executive magistrate Kuch Bihar is be transferred to the learned subdivisional magistrate at Barrackpur, North Chobbish Pargana. The transferee court within a period of 4 weeks from date of communication of this order. The transferee court shall proceed from the stage reached at this date, till this date. From the stage reached till date. Upon receipt of the case records, the transferee court shall serve notice upon both the parties before proceeding further with the case. Petitioner is directed to communicate this order to learned subdivisional executive magistrate Kuch Bihar. All kind of applications, if any sense this one.
Highly obliged, my lord. Highly obliged.
नहीं भेजेगा क्यों? Second up, I'll be taking up civil matter. Who is for the petitioner? Oh, देखो online 10. Mr. Basu is there.
Can you take up the matter tomorrow?
Tomorrow, I will call. I don't know whether I can reach, but let me the list if I take up tomorrow, huh? Second up, I will take up the civil matters.
Very well. According to your loss of convenience, you get the matter.
Thank you, Mr. Basu. Okay. Chalo.
রিপোর্ট আসার পর আগে যে ঘটনাটা হচ্ছে এটা একটা বাংলাদেশি লোক করে লোকটাকে সাজা দিয়ে দিচ্ছে নাইট আইটেম 9 স্পেশাল কেস এটা বাংলাদেশি লোককে সাজা দিয়ে দিচ্ছে এবার লোকটা সাজা থেকেও গেছে তারপর জেলে বন্ধ মানসিক ভাবে ও ভারসাম্য এবার ওর যখন মানে ইয়ে করতে গেল ন্যাশনালিটি ভেরিফিকেশন হলো পোস্ট কনভিকশন মানে ইয়ের সময় আপনার পুশব্যাকের সময় তখন লোকাল টিম কি দেখলো ও একটা মানসিক ভারসাম্যহীন লোক ওর বাড়ি ঘর ইন্ডিয়া তো ইন্ডিয়ান লোক ও পরিচয় দিতে পারে না বাংলাদেশি মানে কোর্টে চালানো লোকটা ট্রায়াল ফেস করে জেল কেটে মানে এত বাজে ব্যাপারটা আমি তো সেটা আছে রিসেন্টলি আমাকে যে বিয়ে থেকে আমাকে ফোন করলো একদিন আইজিপিসি তে গিয়ে ফোন করলো একটা ঘটনা হয়ে গেছে আমরা ইমিডিয়েট রেজিস্ট্রি রিপোর্ট পাঠাবো ওরা বলছে আমরা রেজিস্ট্রি রিপোর্ট পাঠিয়ে দিচ্ছি দেখুন অর্ডার ছিল প্লেস করা দিয়ে এই লোকটার কোনদিন জাস্টিস পাবে না যদি হাইকোর্ট থেকে ডিসমিস হয়ে যায় এই লোকটা জীবনে জাস্টিস পাবে না বাংলাদেশ চলে যাবে ভারত
ডিপার্টমেন্টে দেখুন
তিনি দেখুন রিপোর্টটা
এটা অর্ডারে কি আছে রিপোর্ট দেওয়ার
রিপোর্ট প্রডিউস
এটা চালু করে এটা একটু দেখি একটা মাননীয়
আমি কোর্টে করেছি ওটাকে ডিফেন্স
মার্কে পাশে থেকে
আমি
নাম্বারটা বলতে
হ্যাঁ
বলছি যে আপনি
An application under Article 227 appearing for the first time. That we have read several adjournments, I'm extremely sorry.
Yes.
This is against Miller, an order dated 10th of January 2024 passed by the tribunal.
Page number?
Miller, the certified copy, which is annexed to the application. Now, our contention is Miller, the order apparently Miller on the face of it is absolutely perverse. Because of the reason, before Miller takes up the brief, Miller, I'll just state in 2 minutes the facts. Now, Miller, initially, Miller, a loan of about 5 lakhs was obtained by this petitioner. Subsequently, the loan could not be repaid. Miller, they have initiated appropriate proceedings, the bank appropriate recovery proceedings, and Miller, subsequently Miller, the sale of Miller, the mortgage removable property was held on 23rd November 2012. The sale certificate was issued on 20th August 2013. The amount realized was Miller, around 12.45 lakhs, which was Miller, in excess of the loan amount due. So therefore, Miller, an amount of 7,54,000 was refunded to me. The matter came to an end. Subsequently, Miller, after the sale was absolutely completed, the bank Miller preferred an application under Section 14 of the SARFAESI Act before the district magistrate, stating they are unable to secure physical possession of the property. So, without even assuring Miller the physical possession, Miller, the bank went ahead with the sale, confirmed the sale, took the money from the successful bidder, refunded the excess amount to me, and brought the matter to a closure. Then, Miller, once in 2013, 30th December 2013, they preferred an application before the district magistrate under Section 14 of the SARFAESI Act. Now, subsequently, Miller, all of a sudden, without serving me any further notice, another original application before the debt preferred tribunal is being preferred by the bank, saying that since we could not deliver physical possession, now the amount which have been paid by the successful bidder in the earlier sale, along with interest, requires to be returned by the bank. Therefore, you are liable to pay this amount. So in the second original application, they made a claim of rupees 17,51,000. Now
That chapter closed. The earlier one closed.
Earlier one was closed. They refunded me the money. Thereafter, they could not deliver possession to the successful bidder. The successful bidder said that since you cannot give me possession, return me the money along with interest. Bank was under an obligation to repay. Now, once the bank has paid that amount, the second original application against me was preferred by the bank. I preferred my written statement before the debt recovery tribunal. I said that the property which was mortgaged before the bank, that was under sheet number 13, Khotian number 2778, plot number 383934, which was Miller, the title deed, which was mortgaged, deed number 431 of 2021. At the time of delivering of the possession, bank described a completely different property which is situated in sheet number 9 of the adjacent moja and showed that this is to be the property. So naturally, they would not be able to deliver the possession. Now, Miller, ignoring all these facts, Miller.
Where is that later of? Where is that?
Miller first.
Section 14.
Yes, I'll just take your lordships first. Miller would take the deed first, just to Miller have a look at the schedule. That is Miller, the deed, which was the mortgage property that starts at page 79. 79 Miller is the scheduled property of the sale deed, which was the original mortgage property. Miller would find 13 number sheeted, bag number so and so, and Miller, the quantum of the land is also described. Now,
page 79.
Page 79 of my application. This is Miller, the schedule of the deed, which was the mortgage sale deed.
Sheet number 9, where it is? Moja is
just at the bottom, Miller, of the schedule, 13 number sheeted, dark number so and so.
Error number sheet.
And on the next at page 81, Millard would find the schedule of the property. So it was Millard absolutely butted and bounded by a proper boundary. It was an identifiable property. There was no chance of any mistake on the part of the bank. Now, Millard kindly turns over to page 89. That is Millard, the register of equitable mortgage. Millard would find the first document, which was mortgage, that is the deed which I have shown to your lordship, title deed number I-431, dated so and so.
This is issued by the bank.
Issued by the bank, the mortgage register.
Okay.
Now, having put this property on sale subsequently, they cannot come back and say that I could not deliver possession, now I have to refund the entire money. Now, this is not what I had pleaded in my written statement in the second original application, which the tribunal absolutely ignored and proceeded to once again pass an order which is completely against me. Now, Millard takes page 135.
Wait.
One 137 rather. The possession was sought to be taken over, Millard. This was the application I preferred under section 144 before the executive magistrate to resist Millard illegal taking over possession of a different plot which I had never mortgaged. Page 137 at the schedule, Millard would find sheet number 16 and a different plot number.
One 135.
137.
Sheet number 16.
Yes. Sheet number 16. Millard could find it's a different plot number completely. 961 in a different area. Since the sheet number is different.
This property was never mortgaged.
No. And the bank subsequently sought to take over possession of this property. We don't know for what good reasons.
Where is the notice of the bank?
Now, I'll just come to that, Millard. If Millard kindly now takes page 121, which is Millard my written statement to the second original application preferred by them before the tribunal, where I have disclosed this entire discrepancy, which the tribunal ought to have taken note of. Page 121.
Yes.
Para I, page 123.
Yes.
If Millard kindly takes Millard the paragraph, I'll just place it for Millard my satisfaction. That in the meantime, suddenly on so and so, the officials of the applicant bank came and told that they have sold the residential property of the defendant, which was mortgaged by the defendant, and after sale of the said property, the surplus is fixed in the name of the defendant with the applicant bank, and as such, the defendant has to quit and vacate the possession of his dwelling property. It is pertinent to mention here that as per the sale deed number so and so, this defendant had mortgaged his land measuring so and so decimal situated Mouja so and so, Porgona so and so, sheet number 13, Khotia number so and so, plot number so and so, within case Bhaktinagar so and so, which is more fully described in the schedule with specific boundary in the title deed, deed number 431 for 2011, and this is the same schedule of property which is mentioned in the sale notice of the applicant bank dated 12 June 2012. Also, in the possession notice of the applicant bank dated so and so, as well as in the notice of the intended sale, the applicant bank dated 19th October 2012, and also in the paper publication made by the applicant bank in Uttorbang Sambad and so and so. It is further mentioned here that defendant have never mortgaged his dwelling house property situated over the land measuring 4 Gatha 4 Sotok, situated at so and so, sheet number 16, Khotiyan number so and so, plot number 961. It is not out of the place to mention here that the mortgage property and the dwelling house property are totally different. But the applicant bank, without any authority and ulterior motive, tried to oust the defendant from his dwelling house property, for which the defendant was compelled to file a proceeding under 144. Now, the learned tribunal, in ignorance of all this, will once again proceeded to pass an order on the scheduled mortgage property without clarifying that the property situated in sheet number 13 and 16 are completely different, and the bank cannot have any claim over the residential property.
The subsequent application has been filed in respect of both the properties.
No, the same application, the same property.
That
They
means
are
that
showing
was
the same
mortgaged.
mortgage property and saying that you once again return the amount. Well, absolutely a precarious circumstance. So, my respectful prayer, since these are factual things which the bank has to come up and deal with, let the application be admitted today. Let the bank file their affidavit and demonstrate before this court on what basis they have proceeded in this manner.
No, there is no discussion in the judgment.
Nothing. Kindly takes this entire aspect has been ignored by the learned tribunal. That would take page 9 of the judgment, the last property, the operating portion of the judgment. I am aggrieved by para 4, Roman 4, where the tribunal states, internal page 9 of the judgment, para Roman 4. The defendant is debarred from transferring, alienating, encumbering, or disposing of the hypothecated mortgage properties or any other property and assets belonging to the defendant till the aforesaid adjudicated debt amount is recovered from the defendant. So that when a property is clearly mortgaged, the title deed was subjected to an equitable mortgage, how my other properties can be kept under cease? And now the bank, after having this order in their hand, they're repeatedly coming to my residential property where I stay with my aged parents, my children, my family, they're seeking to evict me because my all properties are said to have been kept under under the operation of this order. The tribunal ought to have clarified that you cannot go beyond the property which has been mortgaged. At least at a belated stage, when you have conducted the sale, you have issued the sale certificate, everything completed.
Show me a document that this particular property, the second one,
yes,
has been, put into execution by the bank to take over possession of that. Any
yes.
notice issued or section 14 application before the district magistrate?
I will show your lordship a better document, Millard. The order passed, my 144 application, which I have to prefer to secure my possession, I have brought that to your lordship. Millard, I'll just show the order. Page 133.
What is the subsequent order pass? The
Yes,
report has been,
when Millard subsequently the bank came to take possession of my dwelling house. I have shown Millard the schedule of the 144 application, which is my dwelling house property, and I was protected from being dispossessed from that property. So this is the best document, Millard, which I have to demonstrate that I was actually attempted to be dispossessed and I was stopped by a court of law.
any civil suit filed by the petitioner?
Millard, to my knowledge, Millard, I have no instructions to that effect.
And what is the contention in the criminal proceedings?
Millard, in the criminal proceedings, Millard, a complaint case was filed against the officials of the bank that you have proceeded wrongfully. Millard,
No. In page 139,
Yes,
the
sir.
Indian bank as complainant has lodged a complaint against you.
Yes, that is Millard, that we are resisting taking over of possession. Millard, kindly see page 39 is the notice which mentions the provisions. 406, 420, 468. And Millard, the next page is the complaint.
Okay. So residential house is separate and the land is separate.
Yes, different area, 2 sheet numbers.
Section 14 proceedings before the district magistrate.
Yes,
Where is it?
Millard, not very sure, Millard, whether we have annexed it, Millard, I'll just check up, Millard. The section 14 order, Millard, probably has not been annexed, Millard.
That is the
Millard would find admission of the bank at page 103.
103.
103. Hundred and four, the first paragraph, Millard will clarify this. This is Millard, a communication addressed by the successful auction purchaser, who has actually stated what was the real position there. The first paragraph at page 104.
Then what was noticed or what was the advertised?
Yes, that Millard we have at page 96. The notice of sale under rule 6.2 and 8.6 of the service rules. Page 95. 96, Millard would find the schedule. would find the same property which was mortgaged, the description which was there. Now Miller takes 101 after the sale was completed. What they said? 101. This bank's letter. Due to non-payment of loan, bank has sold your land and building as measuring so and so decimal, plot number so and so, 383/934, Khotiar number so and so, sheet number 13 at Chhot Pradhanpada, Jotiagali Mode, Fulgarihat, Pranatiwar, and appropriate the sale proceeds as follows. What wrong I have done? You have sold my property, you have realized a particular amount. Then you come back and say that there was no property in existence, hence you are required to pay 17.5 lakh rupees again, because we have to return the sale proceed to the successful auctioneer.
The amount has been refunded to the.
Yes, yes, it was refunded to me. And for me, it was a
No,
good
the
step.
amount has been refunded to the purchaser.
Probably yes. That's what they say in the subsequent notice before initiating the second proceeding. Willard once takes page 112.
Just a minute.
Yes.
How did you got the dwelling house?
Milord,
How did you have purchased the dwelling house? Or is it part of the sale deed that was mortgaged?
no, Milord, the sale deed which I have mortgaged, Milord, is a purchase property. Which
What
was
about
mortgaged.
the other property which the bank intends to
Other
take possession of?
property, Milord, is also a purchase property, but that deed we have not annexed in this application, Milord, because that
No,
was not,
that is required.
that was not called into question before any court of law. That's why, Milord, we have not annexed that. If
No.
Milord desires, Milord, we can bring that by way of a supplementary.
Yes,
application.
you bring that because
Yes,
the identity of the property, the
Yes, sir.
judgment which has been passed by the tribunal has proceeded holding as if the land and the dwelling house is one and the same. It identifies.
correct.
Come to page 7.
That-
It
that's
says
why,
that
Milord, that's that.
in the
agrees.
north, south, east, west, since it is butted and
Yes,
bounded
yes.
of the same,
Yes,
hence those are identical and it can be put into
correct, correct. Milord is absolutely right, because that is also the point where I am
because the only ground which has been taken is that the properties are separate and distinct.
Yes,
One that is mortgage and one
one which is
which-
not mortgaged.
right, not mortgage, distinct.
Yes, and the
You
one
file that.
mortgaged is a vacant land,
Hmm.
the one which is not mortgaged is having a. building.
29th, I'm placing it, file a supplementary affidavit annexing the
Milord,
Section
please
14.
say this, Milord, to my knowledge, Milord, this petitioner, Milord, is outside the jurisdiction of this court, is presently in Odisha. And Milord, this deed has to be supplied by him. So Milord, can I have at least 7 days time to file the supplementary? affidavit?
Then you have to go before the next circuit. Mr. Ghosh, learned advocate for the petitioner, seeks leave to file supplementary affidavit annexing the deed what is this property specification deed?
Milord, 137 bottom, which is Milord my dwelling house. One three seven.
Deed of the dwelling house property situated over land measuring 4 katha, 8 chatak, Mauja, Binnaguri, Parogana, Boikuntapur, seat number 16, RS Khatian number 358/14, Hal Khatian number 3547/6, plot number 961 within PS Bhuktinagar district, Jalpaiguri. As well as the notice, the order passed,
Section 40.
order passed by the district magistrate Jalpaiguri in under section 14 of the Surface Act. Leave granted. Let the matter appear before the next available circuit.
Great.
নেই কেউ এটা কি পার্সেলে আসছে নট টুডে ডেটটা দিয়ে রাখবেন যে আজকে কল হয়েছিল Nidhi, not today.
Ajay single appearing, Worship. He is appearing in court room number 1, Worship. So kindly make it short passover.
Not Passover. The 3 I will be taking up the FMA tonight. Actually, not today, confirm. Tomorrow. Next.
I don't know, I am for the petition. Actually, the case, the petitioner was a plaintiff in a suit. And the opposite party, while they put in the cross examination, he admitted that there is a suit pending before the Darbhanga, Bihar, with respect to the certain property, and that has been admitted by the opposite party. And in cross examination, he admitted that there is a certified copy also. My lord, therefore, the certified copy which is produced before this learned trial court below, that was not been exhibited. And it is marked for expiry. Now, my lord, kindly allow me to the petition is concerned. Lordship, first of all, the plaintiff is concerned, that is been page number 13. This is the petitioner hearing, and the opposite party number defendant has filed the written statement at page number 22. Now, my lord, when the issue has been framed, the petitioner was examined as a PW1 and that has been discharged. Thereafter, DW has been come into existence, and the opposite party number 1 was examined as a DW, that is in page number 33. My lord, can you see that?
Page number
30.
33.
33 and 1.
The petitioner is the defendant.
I am the plaintiff.
You are the plaintiff.
Plaintiff.
Okay.
Petitioner is the plaintiff. And opposite party is the defendant. Now, Lordship, kindly comes to the page number 33. That is in cross examination. Lordship, kindly the 33. That is been clear. Now 34 onwards, 34 he was examined, and the penultimate paragraph of the cross examination that my brother and sister have filed a civil suit against myself, which is lying pending before the civil judge, Junior Division, Darbhanga, bearing number 4444 of 2018. Lordship, got it? Thereafter, my lord, can you have page number 35? Middle part. That I have mentioned in para number 9 of my written statement against the civil suit bearing number such and 44 of 2018, which is lying pending before the civil judge Junior Division, Division Darbhanga, that my elder brother, namely Sri Binod Mandal, is residing in Katihar, and he purchased the land and constructed a building there. Therefore, they admitted that there is a suit 44 of 2018. There is a suit, and that is pending before the land civil judge Junior Division Darbhanga. Now, this certified copy has been produced, and thereafter the certified copy has not been exhibited. Now, my lord, comes to the page number 36. Where is my petition has been filed? Kindly, the certified copy has been produced, that may be exhibited. Because of that, admitted position, and the certified copy is there. So the plain and written statement of the Darbhanga case, that may be exhibited. My lord, now, my lord, the certified copy, whichever I have been produced before the learned trial court below, that is been starts from annexure F, page number 39 to onwards. The written statement and the plain also. That is a certified copy on the Darbhanga. Now, my lord, kindly come to the imping order. That is the last part. What is my lord? That this is today's fixed for passing order. Learned advocate on behalf of the plaintiff wants to exhibit certified copy of the plain, which was part of the record of title suit number 444 of 2018,
pending before the learned court of the civil judge, senior division, Darbhanga. The judgment has not been pronounced in the matter. Learned advocate on behalf of the defendant has raised vehement objection. This of the view that since the certified copy of the plaintiff is not a public document and the learned advocate for the plaintiff has not produced the original copy of the plaintiff, it cannot be marked as exhibit in the present case. Therefore, the certified copy of the plaintiff or marked X for identification. This is the impinging order. So, my lord, this certified copy has been issued by the competent authority, by the jurisdictional court. That has been page number 41 and onwards, and that has been admitted by the learned trial court. Now, my lord, the certified copy has been exhibited as a secondary evidence because of the original cannot be accessed by the petitioner, because of that is lying in the judicial custody. It never will come into any court until unless this is the appeal authority. My lord, kindly see the page number, kindly section evidence act, kindly 65. My lord, can you what is it? Worship, the secondary evidence. Secondary evidence means and includes certified copies of given under the provision of hearing after content, copies made from the original by mechanical process, which is in the themselves ensure the accuracy of the copy, and copies compared with the such copies. Copies made from the compared with the original. My lord, the copy has been compared by the judicial authority, and that has been certified copy that is been embossed. Now, my lord, now 65, section 65 is to state that secondary evidence may be given of the existence condition of the contents of the documents of the following: when the original is shown or appears to be the possession of power of the person against whom the document is sought to be proved, or any person out of reach, not subject to the process of court of law, or any person legally produced. That is been, it is not by access by me. That is, the original is lying at the judicial custody of the Darbhanga court. Now, it cannot be possible to produce the original because of the case is pending. This comes to the secondary evidence, and that certified copy has been marked by the judicial authority that this is the compared, that is my lord can find from there. Just we need the page number 4. That is 4. No, that is when 39, 40, or 40 and onwards. That is been their stamp compared by me. Pratilipi Pramani. That has been also been enrolled. So there is a certified copy that is being judicial custody. That I have to produce a certified copy before the learned trial court. That not been exhibited because of there is not produced by the original, because original is not my capacity to bring, and the certified copy should be as per section 65. I am producing, and this is a secondary evidence. So that will be exhibited, and the impugn order, it has been admitted by the trial court that these documents is lying in the upper court, senior division. And I am this case is pending before the junior division Alipurduar, the higher authority. It's not possible to call for anything. Lordship, kindly admit my dispositions and pending this here, the petition, this stay may be granted. Lordship.
What is the stage now?
With this
DW
stage of the Lordship,
DW complete?
on 7th February 25 for evidence of DW3. Unless only Lordship kindly, I am not being allowed to exhibited that documents, the case has been completely completed. That is been shown in the
This
7th
civil revision,
February
this
2025.
civil revision is filed challenging order number 56 dated 11th November 2024 passed by learned civil judge, Junior Division, Alipurduar, in connection with title suit number 164 of 2017. Rejecting the prayer of the plaintiffs to exhibit certified copy of plaint, which was part of certified copy of the plaint in title suit number 444 of 2018, pending before the learned civil judge, Senior Division, Darbhanga. The brief fact of the case is that a suit for eviction and injunction was filed by the petitioners where are the other plaintiffs?
Lordship, so only one plaintiff is come.
Huh?
Lordship, only one, that has been plaintiff number 3. That is, he is a petitioner, my lord. He is
No, where are the other plaintiffs?
No, they are not. I mean, my lord. Only
Why?
single one is they come before this, my lord.
Why?
They are not able to move. Because they have to put signature, they are unable to. That is been petitioner number plaintiff number 2. That is
The plaintiffs, the petitioner, the plaintiff, filed a suit for eviction and injunction during the stop. Evidences were adduced on behalf of the plaintiffs and the defendants. At the time of cross-examination of DW1, no, at the time of cross-examination, DW1, Bhola Roy,
opposite party number 1.
opposite party number 1, admitted of the pendency of the suit being title suit number 444 of 2018 before the civil judge, where is the certified copy?
Lordship, that is 39, based onwards.
Before the civil judge, Senior Division, Darbhanga. Again, Nicola. It is definitely. Pending suit is before the junior division.
That has been, I saw, this Lordship, kindly, I think it has been, when the oral statement is going on, there is some mistake have been done. But they see, the certified copy is senior division. And that is been also been admitted in the.
Senior division, there can be 444. In junior division also, there can be 444.
No, Lordship, because of the, whatever we have produced, that is means, senior division, that is means some impugn order, also refused. And this will be admitted. The impugn order also stated as senior division.
Admission is not of senior division. Admission is of junior division. Not once, twice.
Yeah,
In
that
page
is
35 also it says that it is pending before junior division.
bearing number 4 and 4 and line pending for the CJ junior civil judge, junior division Darbhanga. It is stated in the year. But that is been actually there been the misconception of that because of their cross examination. But there is been admitted that the senior division. That is that.
Where is the admission?
Lordship, because of the whatever we have produced and they have been stated, yes, my brother has been instituted the suit. That is been stated. Same has been content in this certificate.
Then this application has to be rejected.
Lordship,
This application has to be rejected.
Lordship, because of the certified copy is the original one. That is that does not mean Lordship that we have produced another one. That is not because of they have admitted that the case has been pending between my mother and me.
Who is the mother?
My mother, brother.
What is the name of the brother?
Brother, Lordship, that is Bhola. My lord. My lord, kind page number 44. Binod Rai, Binod Mondol. This is plaintiff. Sushila Devi, widow. That is my and Bhola Rai. That is the second one. And the Binod Mondol. Binod Mondol also in the plaintiff.
Suit is
Bhola, baby,
pending
baby
before.
Devi, Lordship.
Before sub judge
Division.
Darbhanga. The petitioner in the suit, he is only the contesting or pursuing the case.
Lordship.
Petitioner
This petition.
filed an application in the suit for exhibiting the document, exhibiting the certified copy of the plaint
And it is.
and the written statement filed in title suit number 444 of 2018. The said prayer was turned down. Hence this revision. Mr. Swansol, an advocate for the petitioner, submits that the learned trial court ought to have exhibited the document in terms of section 65 of the Evidence Act. since the pendency of the suit was admitted by the defendant. Right? Your document and your averments in the petition is contrary.
So far, court is concerned. Lordship, that has been, when the cross-examination has been done, that has been stated, your case is pending, they have been admitted, yes, case pending, but the court is actually differ. But so far, production, whatever we produce the documents, that has been admitted, number is been admitted, Lordship. And the party has been, also party has.
No, you are not understanding it. In one court, this court has a case number 1, the other court has case number
Yes,
1.
yes, my lord, that is admitted, correct.
See, come to page 9, paragraph 10.
Of my petition.
Yes.
Paragraph 9. Learned trial court as not to consider the opposite party, this is examination of the and a civil judge junior division Darbhanga Bihar and certified copy of the plain lordship, that is I have been signed from the deposition. Kindly allow me the next time I'll correct it. Because of it is a senior division. No.
Mr. So learned advocate for the petition. Throughout the petition, you have stated civil judge junior division.
That has been written in the
Mr. So learned advocate for the petitioner clarifies that the court in which the civil suit is pending is learned civil judge senior division, Darbhanga, Bihar, and not learned civil judge junior division, Darbhanga. Upon perusal of the evidence on record, evidence appended to the petition, it is found that DW1 Bhola Rai has admitted of the pendency of the suit being number 444 of 2018. The petitioner produced the certified copy of the plaint and written statement obtained from the civil court at Darbhanga. This court finds that an arguable case has been made out relying on section 65 of the Evidence Act. Next, accordingly, the civil revision is admitted. Issue notice upon the opposite parties.
For the time being.
Vis-a-vis stay of all further proceedings in title suit number 164 of 2017 pending before learned civil judge junior division, Alipurduar, for a period of 6 weeks and on further orders, whichever is earlier, parties shall be at liberty to pray for modification, variation, extension and vacating of the order upon notice to the other side. Petitioner is directed to serve notice of this application upon the opposite parties through registered speed post with acknowledgement given, file affidavit of service on the returnable date list this matter before the next available circuit bench.
Deep level, deep level.
No, admission done. Admission or hearing. Not you.
Deep level.
So in this matter, very large for the applicant, the lordship can see the last one and lordship first in this matter. The lordship directed the department to send down the certificate copy to the concerned for correction. But
No, how long it will take? In the month of June, this order was passed.
month of June, your lordship, last 2024, your lordship. Unless this certified copy has been sent to the learned tribunal for correction.
Subir Banerjee, learned advocate by appellant's claimant, submits that by order dated 20th June 2024, certified copy of the impugned judgment and award was directed to be sent to the learned tribunal for causing necessary correction. However, till date, this certified copy has not been sent to the learned tribunal for effecting such correction. He seeks for necessary direction. By order dated 20th June 2024, the certified copy of the impugned judgment and award was directed to be sent to the learned tribunal for necessary correction since there was certain defects. And it was also directed that such corrections should be undertaken within a period of 7 days upon receipt of the copy of the order. And be returned to this court forthwith. Here is the report of Assistant Registrar, Circuit Bench of Calcutta High Court at Jalpaiguri, dated 10th July 2024. It is found from the aforesaid report that the certified copy was sent to the learned tribunal on 10th July 2024. No further report has been furnished by the Assistant Registrar as to whether the certified copy of the impugned judgment and award has been received upon correction. Accordingly, Assistant Registrar, Circuit Bench of Calcutta High Court at Jalpaiguri is directed to furnish further report disclosing whether certified copy of the impugned judgment and award has been received after correction or not, positively by the returnable date. Leaves this matter on if the order to পাঠিয়ে দেবেন 30 তারিখ 30th January. Not today. কি আছে কোনো ডিরেকশন ছিল দেখি কি ছিল None appears on behalf of the appellant's claimants. Release this matter before the next available circuit bench.
There is no delay. And another appeal is also continuing.
Actually, another appeal has been filed by me also.
I am on the other.
What is the stage of that appeal?
Actually, hearing state.
Hearing stage?
My number certainly both the appeals be heard together.
What is your number?
Number is 62/24.
It is a
FMA.
defective. Why defective? It? Statutory deposit has not been made. Section 5. What is Can 1 of 2024?
Pre-application actually. It is not pressing for that. Right?
Stay. Then not section 5.
No,
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 second. Okay, only.
there is no execution also.
Stay. There is no section 5.
No.
Only order to serve notice of Can 1 and stay application has been served.
Yes, copy has been served.
Where is the affidavit of service?
So for the instruction of my client is concerned, Lordship, copy has been served. Lordship.
What is the ground of appeal?
There was no any insurance policy.
Insurance policy.
Yes. Insurance policy was not ever aggregated before this court. We have category policy stated in our statement that no such policy was ever issued. And this case is under 163A. But there is a 17,000 was awarded by the learned tribunal, which is not tenable in the higher court.
That is okay. But so but the policies council, Lordship, yeah, policy has been duly executed.
No.
And no effort was given from the side of the insurance company to prove the policy that policy was paid.
Policy was not.
They have not been able to prove that the policy is paid.
Policy was not.
This please take in.
In which paragraph this validity of the policy has been discussed? In which page?
In WS page number.
The page.
The owner doing by the terms. Not the policy.
Number 6. Paragraph 15. Memo.
Memo of
Memo.
There was no policy.
That is your question.
You got the written statement?
In different statement.
Lordship, I have prepared one paper book, Lordship, in connection with my appeal, Lordship. So in that paper book, Lordship, page number 51 to 54, that shows the inference policy, Lordship, which is our challenge. Lordship, wrongly, but I apologize, Lordship, wrongly, I have. That is a different way of thought, because the case, it is Gori. On the policy from the. Yeah, just mentioned in the paragraph number 9 that policy was not covered.
Whether the vehicle was on a cover valid until March. Which paragraph?
Paragraph 9, at the top.
OP liability was not covered.
That was just stated. But I've got the policy, Lordship. Which shows that actually
Vehicle is
vehicle was
being
being
registered.
insured at the time of accident.
Which page?
Page. Page number.
Where is the policy?
We have got no any policy, and policy was number.
They are challenging the policy, but they do not have the copy of the policy.
Where is the copy of the policy?
I have, but today I have not brought it because this is not my appeal, so.
No policy was not that.
This appeal has been filed by Mr. Pushpati Nath. For the side of the
As you
insurance
said,
company.
vehicle had valid insurance.
If the Lordship wants to have a look at the policy, Lordship, kindly fix it tomorrow, Lordship, I will produce the copy.
Coverage, exhibit 6. Um, in December. When did the accident take place? They have produced the vehicle particulars. This appeal is The owner contested the,
Owner has not got.
yeah. Got you. What is your number, the other number?
62/24, FMAT.
আচ্ছা এটিকে ওর সাথে রেখে দিন। These are the two grounds of your appeal. হ্যাঁ কালকে এটাকে অ্যাডমিট করে একসাথে করবো। Mr. Govindo Saha, learned advocate for the claimants, submits that the claimants have also filed an appeal being
62/24,
FMAT
FMAT.
FMAT MD 62 of 2024. Your appeal has been admitted. Preparation of paper books direction was given. He seeks for listing the instant appeal along with FMAT MD 62 of 2024.
2024.
List this appeal along with on we did number along with FMAT this on কি হতে পারে permission 20th 29th
29. Date for that.
দিয়ে দিন এটা সেদিন দিন
Grateful Lordship.
এটা দিন হিয়ারিং এ যাবে insurance
Basically, that for investment of the company. This is for the public employee. Now, tribunal awarded everything, your lordship, but your lordship, the operating fine on the other amount that was deducted from the gross amount. That cannot be done, your lordship. These are the only points, and the other points, your lordship, interest by learned from my learned advocate that interest has already been given by the insurance company later on, your lordship. So I am not pressing that point. But my only point on the income, your lordship, that the covenant and other deduction that cannot be deducted except the tax portion, but the learned tribunal itself opined that there is no taxable amount, your lordship.
Again, appeasement present income tax on the income received out of our income pay consider this pay structure only
9 your lordship. Paper book page number 20.
Page 8.
Page 9 of the judgment, your lordship, paper book page number 28, your lordship. Judgment page 9.
এটা LCRS ছিল আছে না
That being further decided by government.
Page number 27.
You got it?
29.
Paper book page number 20, your worship, and the judgment page number 9, your worship. Paper book page number.
Yes, yes. I'm going to hold that.
The para, your worship, last but one, it has been further decided.
Income is income minus tax component.
Along with FX books that established income means the income minus the tax component. In this case, no amount was directed towards income tax as the income of the which is did not come within the limits of the taxable. So the entire amount is liable to be compensated to your worship as per the rule, your worship. So deduction made under the PF or the medical, that cannot be deducted, your worship.
Where it has deducted?
You know, if I will see the deduction, the London judge made. Page 8, paper book page number 27.
Yes.
The para as regards income.
Yes.
The as regards income of the deceased, one life discussed amount from Assam has been examined at PW3 while imposing on dog with witness on dog. This witness has produced a salary slip of the victim, Sipai Vijay Chetri, for the month of April 2021, which has been marked Exhibit 8. In this case, from Exhibit 8, it has been clearly proved that at the time of his death, his gross salary was 41,205. This amount should be considered, your worship. As per settled principle of law, HRA, medical allowance, professional tax, and income tax is required to be deducted. Now, learned judge himself opined that tax is not liable to be deducted since there it is not taxable. But these three items, your lordship, that cannot be deducted in view of the Supreme Court judgment, your lordship, and also your lordship also decided there are several. So, your lordship, on this point, your lordship prepared one calculation.
So 41,205, this is not taxable.
No, your learned judge deducted 5,800. That cannot be done. Because your lordship, the medical allowance, provident fund, that cannot be deducted, your lordship. Since there is no taxable component, your lordship, the entire 41,205 has to be calculated or taken into consideration for calculation.
Yes.
The victim was 24, your lordship.
Other aspects are correct. Yes.
Lordship, in this case, I am just referring a Bombay High Court decision, just for reference. In that case, my point of view is there, my argument is there, Lordship. The amount which were paid to the deceased by way of costs should be taken into consideration for computation of the monthly income, providing the costs were for the benefit of the family, not the benefit of the deceased. And the income of the deceased, in that case, should not be included in the monthly income. In this case, page 30, paper. Page 30, the allowances, liberation allowances, 738, and recurring allowances, 2253, my lord. Page 30, as per paper.
Page 30.
As per paper, 30 or 30? 29.
30. See point
Yes.
plus
That the
those things. Without
liberation allowances, my lordship.
group insurance.
Liberation allowances and recurring allowances.
Ah.
Recurring allowance includes 47, then the total that includes RAM CIG. That is the
What is RAMS? What?
some liquid. In my opinion, it should not be included in the. It may be given to the service man.
What is RAM? I don't know. What is RAM allowance? What are you submitting?
It is in 47, my lordship, page.
Which page number?
Page number as per paper. Yes, Prime Minister, 47, last page. Last page.
Yes.
Right question.
Income tax 0. This has been exhibited. Exhibited.
It is there, Your Worship, this is a
Exhibit.
Total
eligible.
into 41205.
Yes. Last question. Right, last question.
Ah.
This is RAM CIG. If we get to if we HRA, HRLF and RAM
Advances
CIG
paid in a
57,
month.
then it comes into 2253.
Two.
2253. That means the recurring allowance.
Ah.
Then we go to again on 30 page 30. This recurring allowance.
Ah.
So my argument is that the Government Tribunal was currently disallowed this portion. And another question is that I am just referring a Supreme Court judgment that whether the mother is entitled or not. Considering was given to 40,000.
Krishna had calculated 30,000, not 70,000.
This is my argument. Yes, given this in the judgment. And I am giving also another judgment that this appellate court has every jurisdiction. If we are not pleaded, not cross-appeal, then also can appellate court can. This is the Supreme Court 224 judgment.
Very well.
Clear submission is that, my lordship? AHRA, house and allowed as per law.
So law,
House rent, which is not granted, 2015, it should. But
the recurring allowance has to be deducted as per you.
not full. Recurring and allowance includes RAM, HRLAF and HRA. HRA would be 2015. This is the
HRA is to be added.
2015, that's the.
Who is the claimant here?
HRA which relating to house rent allowance, your lordship, that should be granted, your lordship. And the last year, lordship, the Ram CI area, this is one type of group insurance. Group insurance is given, your lordship. As per the Supreme Court judgment, insurance is given, group insurance also is given. Sunil Sharma judgment is clear, your lordship.
It's not actually categorically.
Supreme Court
You
decided.
you are carrying
the point.
Pranay Sethi. You are
Sir.
carrying the decision in Pranay Sethi.
Lordship, Sunil Sharma, your lordship, kindly ignore my pen mark. Paragraph 11, your lordship. Paragraph 11.
Para 11.
Based on the aforementioned judgments, paragraph 11. It is Sunil Sharma, your lordship.
Should not have been killed. You have a copy of the Pranay Sethi? Since he's not pressing the filial consortium, he's not pressing for filial consortium. So that chapter goes. So far as the other decision you have placed that whether it has to be pleaded or not, that also goes because he is not pressing for filial consortium. Now we are concerned with the income.
We take a general deduction, your lordship, 40,000 would not go. I have calculated on the basis of 30,000. This was a bachelor. Multiplier is correct, your lordship.
The paragraph 46. Wait, I can read it. Paragraph 46. What is the definition of income?
Income.
No, you read that in
Yes,
pronunciation.
income means actual income less than tax paid.
No, you argue.
There is no tax, your lordship, already learned it.
Wastage of time. Asun. This appeal is preferred against the judgment and award dated 13th June 2023, passed by Learned Judge Motor Accident Claims Tribunal. ওনাকে একটু এটা দেখিয়ে দিন না। See the calculation. You have received the compensation.
Receive the compensation amount. And lordship, my learned friend instructed that already my client have received the interest portion later on. So you also I am not claiming that. Only interest on this out in a amount.
Okay. Learned Judge Motor Accident Claims Tribunal, come, Additional District Judge, Special, Third Court, Jalpaiguri and MSC case number 393 of 2021, granting compensation of rupees 5881588 under section 166 of the Motor Vehicles Act. The brief fact of the case is that on 16 June 2021 at about 8 p.m., while the victim Vijay Chetri, along with his friend namely Vishal Chetri, was proceeding toward Chanda Company from Odla Badi, and when they reached near Chanda Company, Bagrakote, under PS Mall, District Jalpaiguri, the offending vehicle bearing registration number WB 74BB-6079, coming in a high speed and in rash and negligent manner, dashed the victim and his friend. Stop. As a result of such accident, the victim sustained grievous injuries on his person and he succumbed to his injuries and died. Due to sudden demise of the victim, the claimant, being the mother of the deceased, filed application for compensation of rupees 6725,210 under section 166 of the Motor Vehicles Act. The claim case was keenly contested by the insurance company by filing written statement. Next para, since the hopefully respond number, insurance company लिखेंगे respond number. One. Since the respondent number 2 owner did not contest the claim application. The respondent number 2 owner of the offending vehicle to file written statement but subsequently did not contest the claim application. By order dated 24th September 2024, service of notice of appeal upon respond number 2 was dispensed with since he did not contest the matter before the learned tribunal. The claimants para, the claimants in order to prove her case, claimant's name, one claimant, prove her case, examined herself as PW1 and also adduce the evidence of how many witnesses? One, Gagan Sharma as PW2 and Naib Subedar Vikas Tamang as PW3. Para, respondent number 1 insurance company did not adduce any evidence. Upon considering the materials on record and the evidence adduced on behalf of the claimant, the learned tribunal granted compensation of rupees 58 under section 166 of the Motor Vehicles Act. Being aggrieved and dissatisfied with the impugned judgment and award of the learned tribunal, the appellant claimant has preferred the present appeal. Mr. Subir Banerjee, learned advocate appearing for appellant claimant, submits that the learned tribunal erred in determining the income of the victim by deducting the house rent allowance he further submits that it is settled law that the actual income has to be determined upon deduction of the tax component from the gross salary. Admittedly, the income of the victim was not taxable. This gross salary of the victim of rupees 41205 per month, 205 per month should be taken into consideration for calculating compensation. He seeks for modification of the award. Mr. So learned advocate on the contrary goal. submits that the learned tribunal has rightly deducted the house rent allowance from the gross salary. To buttress his contention, he relied on the decision of Honorable Bombay High Court, passed in National Insurance Company Limited versus এটা দিয়ে দেবেন। আচ্ছা, মিস্টার ব্যানার্জির এতে বলে দিন যে he clearly submits that the learned tribunal ought not to have granted filial consortium in favor of the mother. Filial. Filial. Having heard the learned advocates for the respective parties, the only issue which has fallen for consideration is whether the learned tribunal erred in determining the income of the victim to the tune of rupees 35874 per month. It is not in dispute that the gross salary of the victim at the time of accident was rupees 41,205 per month, as is evident from Exhibit 8. Admittedly, the income of the deceased does not fall within the taxable income limit. As per the decision of the Constitution Bench in Pranay Sethi versus Omuk, reported in such and such, the actual income of the victim then is actually income means actual income less the tax paid. Since in the present case at hand the tax paid is nil, the income of the victim should be his gross salary of rupees 41,205 per month. The calculation entitled to such and such. It is informed by the learned advocate for appellant claimant that the claimant has already received compensation in terms of order of the learned tribunal together with interest. Accordingly, the insurance company is directed to deposit the balance amount of compensation of rupees such and such together with interest on the balance amount from the date of filing of the claim application till the deposit. Before the learned registrar, Circuit Bench of Calcutta High Court at Jalpaiguri within a period of 4 weeks from date. 6 weeks from date. Upon deposit of the aforesaid amount, the learned registrar, Circuit Bench of Calcutta High Court at Jalpaiguri shall disburse the amount in favor of the appellant claimant upon satisfaction of the payment or payment of ad valorem court fees করে দেবে, if not already paid. With the aforesaid observation,
It is on the NS amount for the date of the filing of the claim application till
deposit 6%. এই জাজমেন্ট এটা দিয়ে দিন তো, এটা তো উনি প্রেস করছে না, ওইখানে দুটো জাজমেন্ট আছে, ওনাকে দিয়ে দিন, আমাকে দিন। এই দুটো তো লাগছে না, দিয়ে দাও।
Lordship.
ডিরেকশন ছিল না এদিকে, হ্যাঁ ট্রায়াল কোর্ট রেকর্ডস আছে, ও ওখানে একটা ডিরেকশন দিয়ে দেবেন, ট্রায়াল কোর্ট রেকর্ডস আছে। এটা নেই ট্রায়াল কোর্ট রেকর্ড, তাহলে কি করে হবে? ট্রায়াল কোর্ট রেকর্ডস হ্যাভ নট কাম।
The paper was prepared the paper before. I also handed over the copy of the paper.
কি করে হবে?
2 or 3 points Lordship only.
আরে your no direction for preparation of paper books. ডিরেকশন নেই তো, নেবো কি করে পেপার বুক? ডিসপেন্স করতে হবে। ডিসপেন্স উইথ করতে হবে তোমাকে প্রিপারেশন পেপার বুকস, or short date দিয়ে এটাকে করতে হবে। What are the grounds?
Future prospect has not been considered. One fourth deduction should be 1/4, whereas 1/3 has been deducted. Medical bills of poultry amount 11,000 has been proved but has not been considered. Jail damage 9,500 has been added instead of 70,000. Multiply 13 applied instead of 14.
166 death case.
Death.
কবে ট্রায়াল কোর্ট রেকর্ডস আসবে? এটা কোনো রিকুইজিশন করে না, স্টেপস নিয়েছে? এটা কালকে চেক করুন তো। হ্যাঁ, অর্ডার পাস করবো নাকি চেক করে নেবেন? তাহলে ওটাকে তো অ্যাটাচ করে দিলেই হয়ে যাবে, তাহলে কোনো অর্ডার করতে হবে না, তাহলে এটাকে প্রিপারেশন পেপার বুকস থেকে ডিসপেন্স উইথ করে দেবো, ট্রায়াল কোড রেকর্ডসটাই তাই, আর না হলে তো প্রিপারেশনের ডেট দিতে হবে, বুঝতে পেরেছেন? এবার চেক করে নি কালকে বলুন, নাহলে প্রিপারেশন পেপার বুকসে প্রিপারেশন ডেট দিন। Let it be checked whether the trial court records have been received. If it is received, you can dispose of the appeal by going through the trial court records. Otherwise, direction has to be given for preparation of paper books.
And
If the trial court records are there, we dispense with the preparation of paper books.
grateful, Lordship.
You take this back, tomorrow একটু check করে নিন। এটা কি? এই তো পাঠিয়েছি।
Lordship, this is my appeal. This appeal has been filed by me, Lordship. But another appeal has been filed by the insurance company, that is number 102 of 2024. So my submission, Lordship, both the appeals may be hard together. I've already prepared the paper, Lordship.
Notices, is it? ডিরেকশনটা নেই। What is your, this is your appeal?
Yes, Lordship.
And insurance company, in the appeal by the insurance company, is there any direction for preparation of paper books?
No. On the application, there was a defect regarding the dates of filing of the application.
The first page was missing.
Yes, we have filed, we have taken steps to that, we have already filed.
That is why it is a right.
So,
When it has been, it is to appear on which date?
29.
29.
29th এটা রাখুন। একটারও তখন in your appeal there was no admission.
No, it was very tight, but there was no error.
Since there was no, since the first page was missing, so
There was a report to go to one event.
report has been solved.
Then you have prepared the paper books.
Lordship.
All the papers are with you.
Absolutely, Lordship.
আসুন তো একটু। হ্যাঁ, this appeal is preferred against the judgment and award dated 31st July 2024, passed by learned judge, Motor Accident Claims Tribunal, cum Additional District Judge Fast Track, First Court, Jalpaiguri, in MSC case number 179 of 2015. Mr. Govindo Saha, learned advocate, submits for dispensing with calling for of trial court records, since all the papers are with him. He undertakes to prepare informal paper books. Learned advocate, accordingly, learned advocate for the appellant claimant,
Lordship,
death case.
death case, Lordship.
Appellant's claimant is directed to prepare and file requisite numbers of informal paper books incorporating waiver. This is ex parte against owner.
Lordship,
He also submits for dispensing with service of notice of appeal upon the respondent number 2, owner of the offending vehicle, since he did not contest the claim application. It is found from the order of the learned tribunal that the claim case has been disposed of ex parte against the respondent number 2, owner of the offending vehicle. In the aforesaid backdrop, service of notice of appeal upon respondent number 2, owner of the offending vehicle, is dispensed with. Is this matter on? Acha. Since respondent number 1, insurance company represented, service of notice of appeal upon the respondent number 1, insurance company is also dispensed with. Is this matter on 29th?
paper book, Lordship.
Oh, he undertakes যেটা করলো না, undertakes to prepare the informed paper books within 2 days. Within 2 days. Now I'm fixing this on 29th, but I don't know what Mr. Bormon's appeal is. What is the stage of that appeal? There is a section 5 application. But if it is within time, then you will not press that.
If the pulse pen was missing, Lordship, that is why he filed the application of section 5, Lordship.
What is the ground of your appeal?
Lordship, for enhancement, Lordship.
And your? ওইটা আরেকটা যেটা বললো সেটা কি দুটো একসাথে আছে?
Only interest, Lordship, interest was not granted.
Only interest?
Only interest, my appeal.
Oh. Implantation.
Delay in logic therefore, implementation of implementation.
How many days delay?
Accident occurred on 22nd, 2014. No. Accident occurred on 2012 to 2014 and AFL lost on 22 after 2 days. No, not it was unknown vehicle, Lordship. Actually, in the affair, the vehicle, the number of the motorcycle which was mentioned, that was wrongly mentioned. Yes. Subsequently, another GT was made, and in that same GT, that was rectified.
ঠিক আছে. Next. এটা রেকর্ডস আছে? এটা রেকর্ডস আছে? রেকর্ডস আছে? না। চেক করুন রেকর্ডস এসছে কিনা, নট টুডে, বুঝলেন?
It is actually unknown judgment.
What judgment?
Impute judgment. There was a point of only upon that point.
Okay.
As you know.
Tomorrow, because there was a direction for calling for a record.
Yes.
There is a letter has been issued by the assistant registrar. Just to have a information from the department whether they have received it or not. Paper books তো আছে। both the parties,
সে কি করছে?
যেটা নেই সেটা তো পেপার বুক নিয়ে করে দেবো। আর যদি উনি করতে চান তাহলে বোথ সাইডস এর কনসেন্ট নিয়ে পেপার বুকের উপরই ডিসপোজ করে দেবো, ডিসপেন্স উইল দি কলিং ফর আ লোয়ার কোর্ট। আগে এটা চেক করে নিয়ে লেটারটা যেটা রিসিভ করে। In 6/11/2024, there was a direction for, and pursuant to that, a letter has been issued on 13/11. Just you find out, if it is not, then we have, paper book is there, we can take it up tomorrow.
May I say one thing? Tomorrow, Lordship is to fix on the pair of petitioner and state, three identical matters here. And Rajdi Bunda will come physically tomorrow. Or can it be listed at all?
No,
To some extent.
there are other motion matters.
That is for this election. Item number 49.
Only on the point of interest, no, because interest are got granted.
You prepare the paper book.
Forty-nine and 50, Lordship, both the matters are arising out of the same accident and both the points of appeal is of the only interest, Lordship.
Only interest. Tomorrow.
49 and 50, both the matters.
49 and 50.
I am on behalf of the respondent also. Insurance company lordship, since the ground for appeal is relating to the interest rate, generally the interest rate is dependent on the bank rates and all. So throughout the years and all, so the rate of interest on fixed deposit has been reduced. So it's been like less than 6%. Kindly that consider that.
এটা চেক করুন রেকর্ডস এসছে কিনা। ইউ হ্যাভ দি পেপার বুক?
Lordship, both the matters, 49 and 50, Lordship.
এটা চেক করুন 49/50, সেম রেকর্ড,
Same record lordship. Separated. The
no,
claimant.
rising out of the same MSC case.
Same accident.
Same MSC case.
Not same, different names. Same accident.
Same accident, two victims.
Two big.
এটাও ডিপার্টমেন্টে চেক করে এসছে কিনা। রেকর্ডস না থাকলে জানি না, তার পরের দিন করতে হবে। হ্যাঁ, লিস্টে রাখবেন, তাকে তো ডিরেকশন দিতে হবে। যেখানে পেপার বুকস থাকবে সেটা ডিসপোজ করে দেবেন। এতদিন আগে কোথেকে আসবে? ইট ইজ আলিপুরদুয়ার, জলপাইগুড়ি। না এলেও আনিয়ে নেবে, কোনোটাতেই তো আসেনি। Let it be checked from the department. We'll see tomorrow. Hmm? এইটুকু সময়ের মধ্যে কি নামবে আর কি আসবে? একই। কালকে রাখেন করেন, ঠিক আছে, কালকে রাখ, ফোন দিতে হবে।
मेरा नाम जान ফিফটিতেও দিতে হবে অ্যাপিয়ারেন্স কি দিতে হবে 49 না অর্ডার তো না কালকে বললে কালকে হবে কালকে আবার হবে দিতে হবে না ডিকটেশন নেই কি লাগবে ওই অ্যাপিয়ারেন্স লাগবে ডিকটেশন হয়নি না কালকে কালকে আবার লিস্ট কালকে আবার লিস্ট আসবে কালকে আবার ওখানে লিস্টে থাকবে সেম হেডিং হেডিং না